No mention. All right then. Yes. The writ appeals are and the writ petitions are accordingly disposed of. In terms of the they would like to they can read, no?
You can read the order.
Read the order. It's available just now. It has long paragraph today, 153 motion cases. So we don't want to you this available. Please go through. Your authority to issue revised bills has been upheld, and
Today is of the no, they have to is the deal that will come to reservation. And their right is only to, but the citizen to get that are not reservation. Right, issue notice.
issue notice.
issue notice.
Notice, what else? Contempt, we have issued notice.
Form one.
I will
No,
take up the pleasure of seeing them behind the bar.
Praying for the fourth respondent state.
Your Lordship's part, report is not intended to be an attack.
Huh? No, so what I mean, contempt petition, we have issued notices to them. What else?
Basically, if we are satisfied, we can issue.
Because the laws, what they that
The first two levels. We want to hear them. One more reason. Yes, one more reason is connected issues coming up before the Honorable Supreme Court on 18/8,
Yes, I have it.
where with regard
That's
to
why.
reservations, what their lordships observed was the recognition of the gender.
No, you will get notice, right? You can't represent respondents right away.
No,
Let
so-
the notice go. Yes,
So far as fourth respondent is concerned, my lord, the
you are
state was
accepting notice, right?
fourth respondent, my lord, was counseling for the
Accepts
state has
notice on
been,
behalf of respondent number 4, Mr.
no,
So and so.
counseling for the state has been, allotments have been not issued, my lord. Till now, my lord.
Whatever it is, let it come by way of.
So he accepts notice on behalf of R4 and issue notice to remaining unserved respondents, and then this thing. So you serve 1 to 3 has accepted notice. If he wants to file reply, it's fine. Otherwise, we go ahead. Yes. Whatever, wherever you file a proof of service, please make a mention. Yes.
May I please announce?
Ah.
It's a revision filed by the
Yes.
petitioner plaintiff Millard condoning the delay of 1018 days.
Yes. You know, Mr.
1018
With your experience at the bar. Yes.
1018
Expression sufficient cause. 87 Supreme Court 1353.
but the admittedly Millard, she came to India
Ah,
in 2021.
this is under Article 227.
Yes, but
The order does not suffer from any jurisdictional infirmity. The court has
the
power to
only thing
reject
Millard, she has not
condonation of delay as well as to accept
no, but she
condonation.
has not explained the delay Millard.
Society is still pending.
She received,
Petition to set aside still pending. Delay condoned.
Only delay is condoned, Mr.
right.
Chakrabarty.
yes, but delay is condoned Millard, automatically the
No, no.
petition is allowed.
Unless you are
Yes.
confident that you don't have a case on merit.
No, Millard, I have a case Millard.
Then you should not object to delay.
No, Millard, 3 years Millard, she received the summons.
Fine.
In between 2 years is condoned by the.
Sufficient cause should receive liberal construction so as to advance cause of justice. 87 Supreme Court 1353 and thereafter several decisions. Keep it.
Following MS Khati.
Yes.
Number of decisions are to.
Give it. We will have to write it for him. Yes. In this petition under Article 227 of the Constitution of India, the petitioner has assailed the validity of the order dated
Dated 13 to 2020.
13 to 2023 passed by the Commercial Court in IA number 354/2022 by which the learned judge of the Commercial Court has condoned the delay of 1018 days in filing an application Scope of 220. Yes.
The respondents were appearing for respondent number 5.
None for the petitioner. None for the petitioner. None for the appellant. The grievance of the appellant in this appeal. No, this appeal has been filed against an order dated
Much of it.
Mayor, please. Delay of 142 days in filing the writ appeal, my lord.
I'm appearing for respondent number 1 and 7, Lordship.
all parties are represented.
Yes, I'm appearing for respondent number 1 and 7.
Everybody is represented or not?
Yes.
Yes.
The limited
Adanki,
request.
Yashwant Nath Sai.
Yes, I filed Wakaf.
Everybody is represented.
Everybody
We are
is
asking you, Mr. Don't say that I have not been heard then. Mark the presence heard on IA number 1 of 23 for the reasons assigned in the application duly support. Notice also I have letter. Yes. None for this parties are represented.
You are representing the respondent.
Yes, ma'am. It's respond number 1. Lords, these
The
are,
Government is the
2 to 6.
connected matter had come up on Thursday or Friday.
yes, my lords. Friday, order
And
has,
what about 7? Mohammed 7. Mohammed Mutsaba. Who appears for him? Yes, respond.
Muhammad Mustafa.
I only appear for respond number 1, ma'am.
Notice on behalf
The
of
applicant,
R1
sir.
and
GP.
so GP for revenue accepted by respondents
6.
number 2 to 6. Issue notice of IA number 1 of 20.
My lord, it
Matters
is court matter.
exposed.
It is court matter in writ appeal
without
79.
Case.
Without hearing other side. Without hearing respond number 7.
Notice has to be issued
What
to
are
him for R7.
principles of audi alteram partem? What is it?
My lord.
Huh? Natural justice, something called natural justice.
Yes, my lord.
Then You point out when respond number 7 is served. What is it covered?
No, item number, writ appeal number 794, 795, the same parties almost.
All right. Okay. So that order will be passed, right? Huh? Not necessary. Yes. Not necessary. Then right, madam, taking into account the nature of order which this court proposes to pass, it is fixed.
Much obliged.
We can file all objections under section 16. So under all objections under section 16. Arbitration Conciliation Act, madam. Arbitration Conciliation Act. We pass the order then, none for the petitioner.
Six dinner. But anyway, they can.
Yes.
That we also.
Yes. We should be pass an order. None for the petitioner.
We can pass it to them and pass actually.
Okay.
So we don't have-
Same order. Site 60 password. Yes.
I'm appearing for petitioner. My lord.
Huh?
This writ petition filed for
Petitioner, respondent. Nobody is for the petitioner. You are respondent.
petitioners.
Then the respondent says it, come here. Appeal under section 17. What happens? This order is under SURFACE Act, right? Notice.
My lord, under section 17 of Surface Act, the essay is pending. Yes,
Essay is pending.
yes, sir.
Then
Because
why this rate petition?
in this case, in this petition,
You have challenged the sales certificate.
sales certificate.
Yes, and sales certificate dated 16/4/19 in an appeal under section 17 of SURFACE Act.
Yes, yes, madam.
Then why have you filed a petition? Can you institute two proceedings simultaneously?
My lord, in
Cannot.
in this case, actually.
No. Has he done it? He doesn't know. You know it. Mr. He has challenged this sales certificate dated 16/4/2019 in this writ petition. He says, we asked him to go to DRT. He says, my appeal is pending. So if his appeal is pending and sales certificate has been challenged,
This state petition would not be made.
Well, actually, we are ready to pay the entire amount because my client lost the entire property.
no.
He was cheated by the bank officials and are want to ask.
All this argue in DRT cheated and all, not what.
Already represented about the.
You approach the bank.
Could not consider my case.
We will grant him liberty to approach you with the stipulation that he or she is ready and willing to pay entire deposit, entire amount. also, you also don't enjoy litigation, right? You are concerned with your money.
Yes, my lord. Our
Right.
only difficulty is the sales certificate has already been registered, my lord. He's challenging the registered sales.
So after sales certificate, probably it's too late for you. So,
There-
Mr.
there
Your appeal is pending.
Appeal is pending, Millard. Actually, transparency made by the,
Mr. Nothing can be
Bank
done. We are
officials-
bound by our own orders. Sales certificate, any measure under 13(4) appeal lies.
because
At least 10 judgments, our orders are binding
Millard,
on us.
demand-
Our orders are binding on us.
Millard, in this case, the bank officials not issued a demand notice to the applicant petitioner, Millard. And as well as position notice also not served. The action sale notice also not served.
All these grounds
For the
can be
purpose
raised
of
in appeal.
IA is pending
The
in the year of
petitioner in this,
2018.
Madam Surface Act, our order. The petitioner in this appeal has assailed the validity of sales certificate dated 16/4/2019. Issued pursuant to e-auction sale notice dated 6/2/2000, judgment 6/2/2019. Full stop. The sale was held on 28/2/2019. Paragraph. Admittedly against the
No.
20342. We want to have. Yes.
Public.
Ah.
Thirdly, questioning the action of the second respondent, Health University, in treating the petitioner as a non-local
Local candidate, Mr. Rao,
Coming day after tomorrow.
Mr. Prabhakar Rao,
No, I'm representing Mr.
covered by your lordship, sir.
First respondent.
Page 104.
list for analogous hearing along with WP number 21893 of 23 and WP number 22021/2023 on 18/8/2023. Yes, madam.
May I please allow it?
Ah,
Lord, writ petition against the
Huh?
minutes of the meeting mail wherein, my lord, I am asked to get the NOC from the DFO. In spite of the fact, my lord, I hold a decree, my lord, that this land doesn't fall under the forest. And there is a decree against the forest department, my lord. The decrees which I have
oh,
produced
decree
are
only
not
says, no. Decree only says you are the owner of the land.
declaration. Notification doesn't read my name,
Yes.
not this survey number.
No. But you are asked this notice at page 20, which you are
Yes,
impugning. By this, you are asked to submit scrutinized quarry plan along with environmental clearance, consent for establishment, consent for operation.
That is,
So merely because somebody is owner, that doesn't mean that he will not obtain any consent and will start establishing industry.
No, Lord,
This
I'm
is
not-
what the challenge is.
I am not challenging the LOI issued in my favor.
Sitting hearing of the committee select today. We find that this particular event. Which to be in a forest land, but we will be large. And also, the updates on the forest department.
You tell them not to this. She can tell you, yes, this is that not forest and decree.
You can even
Beg your lordship.
see, if it is, if it, according to it is not falling within the forest land,
Yes, my lord.
the same thing can be said to them.
My lord,
Use the map and
You
also.
have a decree, everything in your favor. What is your hesitation in going to forest department, showing the same thing that it is not within the
they
forest
are not
department?
considering because they lost the case, my lord. That is my, your lordship so kindly say, my only request is.
No,
you can
madam.
The decree which is not mentioned.
One thing we can tell you that in a 226 jurisdiction, we cannot decide whether your land is situated in a forest land or away from it.
Lord, may I say?
In a forest, this we can't decide. Please appreciate.
I.
You file.
What's passing on in the mind of the court, my lord.
Ah.
But your lordship.
And this is only a notice. It cannot be, notice can be challenged. Notice can be challenged only if it is without jurisdiction. You don't mean to say that these people do not even have power to issue notice to you. This is not, it's a notice.
Notice issued to me. I'm sorry, my lord. In person to the LOI given to me by the state of Andhra Pradesh, by the state of Telangana granting me a renewal of mining
This
lease.
is what she has challenged.
Page number, my lord, my proceedings are only at page number 15 which starts, item number 1 at page number 17.
Said it's in the article. There must be a mechanism.
Sir, the only way is to conduct a survey.
Nice.
At all, they have to dispute whether it is within forest land.
They can make a request.
226, we will not be able to decide this issue, madam, whether it is within forest land outside.
No, no,
May I say, Lord?
are not before this court for a declaration that this is not falling within. Let them consider the decrees. They don't mention in spite of my filing.
They
If
will
they consider
consider.
the decrees and they say it is not applicable to me, my lord, I would go before the
May I say, Lord?
appropriate court.
No, so therefore what we will do, subject to what you say, what we propose to do is that she has got this page 20, right? She will submit a representation annexing a copy of judgment and decree.
Yes.
You take a decision on that representation after hearing the petitioner, whether or not it is, if necessary, you may conduct the survey also and find out and note the contents of judgment and decree. If it is not challenged by you and if you are a party, it binds you, correct?
May I say?
You cannot,
Lord, now the writ petition is filed, Lord, seeking the NOC from the district forest officer, forest department.
Huh?
But unfortunately, DFO is not made as a respondent except the principal secretary, pollution and forest department. Lord, I don't think, Lord, when they sought specific direction, Lord, the mandamus against one officer, Lord, he is not the party before my Lord.
oh,
And may I submit that? Not
they what, just a minute, which mandamus, which page, Mr.
Lord, the prayer part, Lord,
Where page?
I don't have even, Lord, the file also.
Yeah?
They are not served me.
Page 4.
Which is in the writ.
Lord, the prayer part, Lord,
Ah,
asking the
action of R4.
no objection certificate from the district forest officer, forest department for grant of the renewal. Unfortunately, Lord, the DFO is not brought.
Hide and seek. Hide and seek, madam. Hide and seek. This all industries and all this is, you are seeking a direction in the, it can't be this thing. You have drafted it.
Yes.
It can't be an oversight.
Operational committees and it's up to you. I'm not.
Read. No. Read the prayer clause. Read the prayer clause at page 4.
Which is corresponding to this.
Read it. Read it.
The forest area officer also.
No, you delete then. You delete this prayer that if you don't want to
Modify
implement.
it. And
Uh,
maybe you'll have to file a petition for impleading as well as modification of your claim.
I saw for declaration. Action of respondent. Oh.
Asking, no, your grievance is asking you to go before, get a certificate from CFO. That is your prayer. That is why you have not chosen to make him a party. But the thing is now, in the light of the observation, what is falling from the bench, that we would, we in a 226 jurisdiction, we cannot decide the location of your land, whether it is within forest land or outside forest land. Admittedly, that cannot be done.
So what is the remedy available unless until you go before the forest authority saying in the light of this, give me a NOC, or if they don't consider,
So, Mr. Who will consider what's the use of keeping it pending, right? Again, it will come up. Correct?
Lord,
We
it's
are
subject to my lord's, my lord
Who will
intervention.
consider?
Lord, they have to approach the concerned authority, making
Which
the
is concerned authority?
district forest officer, Lord, when they sought a relief,
Which place?
Lord, the, don't know exactly the
Madam,
area.
she has, that's why she has not implemented so that you don't know. She has not implemented because you should not know.
Komaram bin Asifabad district.
Correct, Mr.
With the prayer,
No, you want to cut. See, if you agree, we will pass this order. Otherwise, we will adjourn it, grant her time, again waste of human effort, energy, everything.
no, I leave to my lords.
Fine. Yes.
Unfortunately, I am not the party, Lord, that may be.
But forest department you represent, right?
Principal
Industries common.
secretary,
We can even.
pollution and
implement so-
forest, my lord.
If so.
All right, so we can implead you if you want.
So much.
She can be permitted, huh?
Yes.
Learned counsel for the petitioner is permitted. Yes, next.
My lord, I'm the petitioner counsel, my lord. My lord, the petitioner is challenging the
Yeah, who are you?
petitioner, my lord.
Who, no.
My lord.
This is a public interest litigation.
Yes,
Huh? How are you concerned with this? You demanded money from them, R8 to R15, they refused to give, so therefore
No, sorry, my lord.
illegal construction,
Sorry, my
right?
lord.
That's
Actually,
what I asked you. Who are you?
no.
You said petitioner.
My lord, I'm for the counsel with the petitioner, my lord. And
We are talking
Who is the
about
petitioner?
petitioner is the localized.
antecedents of the petitioner. Writing farmer doesn't help you. Public is everybody.
Yes,
Everybody here is a public spirited individual, right? But there are requirements, no,
yes,
that you have to disclose public spirited antecedents.
Yes, my lord.
The ordinary inference is that he must have gone to them, demanded money. They refused, so he said, "I will file a petition against you in the High Court."
No, kindly permit me, my lord. I'm the petitioner. Already filed number of pills made up, page number 15, my lord. It is not first case.
So your occupation is filing pills, not
No, my
agriculture,
lord.
right?
No, my lord. The petitioner is working as social worker who had filed against
You
the
say
pills.
so.
My lord.
Where have you stated?
I'm not up.
You said a farmer.
Yes, my lord. Farmer and a localite of Peddapalli district, my lord.
No.
No, but where have you said that about a social worker?
Antecedents.
Cause of the.
And you approach the local authorities.
Yes, my lord.
Local authorities with regard to your grievance.
Page number 58.
No, don't disturb. We will not entertain this bill.
Okay.
First of all, you tell us when did you approach?
My lord, 16 to 2022, page number 55 to 77.
16 to 22.
22. And 69 2022, and latestly 8/6/2023. Page number 77.
He is appearing for municipal corporation.
Who is appearing for municipal corporation?
Peddapalli municipality.
Where is it?
So, call him. He will
Call him.
look into it.
Why is it not being disposed? 4 representations are given, they are sitting tight.
They should look into it. This poor farmer, we don't want him to file 18th public interest litigation here. Huh? You should focus on agriculture, Mr.
My lord, yes, my lord.
Your occupation is farmer.
Yes, my lord.
What is the crop which is being grown in your fields right now?
My lord, I am the farmer.
No. What is the crop grown in the fields of the petitioner right now if you are a farmer?
Rice, he's
You don't know. That means not a farmer.
No, my lord, I have agriculture.
So you become, in addition, what you do is you give up farming and become a PIL expert. In addition, become an RTI activist also. So that you will survive, right? Shift to Hyderabad, give up farming, engage. This is all lighter vein, Mr. Huh? Lighter vein. We are suggesting that you take up this PIL 15. You have already filed 50 more. So make it 100 figure. So, and then become an RTI activist also. Mr. GP, he will entertain all applications. So you can write here. Saying that Law is not being, it's like saying that provisions of IPC and CRPC are not being followed, therefore writ be issued to follow. These people are not even parties.
Not yet, nobody selected.
Now, how do you know?
Year 2023.
No, how do you know that nobody is selected? How do you know
Not
that?
yet announced, Miller.
That, huh?
Award is not yet announced for the year 2023.
No. Please tell us, Mr. Award is not yet announced. The cause of action will accrue. Anticipation, can you
Well, last-
just a minute? Listen to us. What matters is our query. So how do you know in anticipation that the guidelines and the procedure prescribed for award of this thing, Sahitya Academy awards is going to be violated? Somebody told you in dreams,
No.
whatever. Who told you?
Your Lordship, my thanks.
This is no cause of action has accrued to you according to us.
Earlier, there was a
Withdraw
direct.
it and file a better petition with when those persons are granted that this particular person has been granted in violation of the guidelines. Then we will appreciate this is Learned Counsel for the petitioner, after arguing the matter to some extent, seeks leave of this court to withdraw the writ petition with the liberty to file a properly drafted writ petition at an appropriate time when the cause of action accrues to the petitioner. Paragraph. Accordingly, the writ petition is disposed of in terms of liberty as prayed for by the petitioner. Next.
CST signature 70.
You are there 66.
My lord, lots of kind indulgence, my lord, in this matter. But on behalf of the first respondent, my lord, I have sent this counter, my lord, for signatures. My lord,
No, you
Monday.
wanted to this after how much time?
My lord, 1 week or 10 days, my lord, 2 weeks.
All right.
Your Lordship, one request, my Lord. On 11th April, Your Lordship has directed the parties to file the written synopsis, my Lord, in this matter, and to be heard finally, my Lord. So I
Let
was,
them file counter,
Yes,
then we
Lord.
fix a date.
yes, Lord.
Mark everybody's presence.
Probably
learn it.
believe that they sought time on last date of hearing.
We know 24 July 23. Again, you just heard him saying that he has sent the counter, which
On
has
Monday
not.
itself.
Lordship will take it on Saturday.
Way from Hyderabad to Delhi appears to be long. There, this thing counter is lost, stuck up somewhere. Huh?
Yes, my lord, I have waited till on Monday. Lord.
19th, my lord, Saturday.
19.
19th Saturday, my lord.
Saturday.
No, it's my lord, next week.
Whatever, we don't want him to this thing like
Yes, Your Lord.
But in advance, my lord,
another time, another opportunity. So let him be satisfied. You file it by positively.
Well,
You tell the date, Mr. 29th August.
my lord, you will bless. My lord,
Mr.
the appearance, my lord, in last occasion it was dispensed.
Dispensed with.
Yes, my lord, but it caption it is coming, but appearance. My lord.
By an order dated 24/7/2023, a requirement of appearance of the officers was dispensed with. Therefore, it is directed that this matter be not listed under the caption appearance on the next date. Paragraph. On 24/7/2023, 24/7/2023, and DSGI had prayed for time to file counter. Once again, today he prays for time to enable him to file counter. Let this be done on or before next date of hearing. List on 24/8, 29/8/23.
Yeah, sorry, in advance, my lord. Okay, sorry, in advance, my lord.
Advance. Yes. Yes. 73 powerful. Assistant motor vehicle. Yes. Yes. Affidavit you have not filed. When? No, no, have you filed it or not filed? When? 14. Why? In compliance of the order dated 31/7/2023, comma, Secretary APPSC has filed an affidavit on 14/8/2023. However, same is not on record. Line below, office is directed to trace the same and place it on record.
You got the copy of the affidavit?
No, we are not served in.
That means,
No, but before, you see, the reason could be for return, you have not served on him. That is the reason office would have taken.
how does it not, this thing? Supply him today. Same on record, then thereafter you write learned counsel for APPSC, whatever, undertakes to supply copy of. This means. Correct, but what is wrong? Who's ordering there, they were there telling me, it took some time to remove that. Why? Password. Password. This we will take at the end of the end of March 30. Not 2:30. Let them wait. They don't come here, we should not facilitate their. This thing. Yes. 75.
Met this well.
But
at the outset, my lord, I express my unconditional apology. My lord.
No, no, why?
The matter got
It's not a
adjourned.
contempt, right?
No, the matter got adjourned about half a dozen times at my instance. My lord, actually,
That's the fun, right?
it's true that we must have.
File the petition, get it listed several times.
Yes, I understand. But the first time it was adjourned because my.
No, we are not into explanation for this thing. When we ask you, then file an affidavit. Right now, we are concerned with what is the
Office
address of the
objection,
court.
office objection, they say that there is no public interest involved. But the registry, in my humble view, a matter of this nature cannot come to a conclusion that there is no public interest involved. There is already one case.
No, who is the person who is, according to you, is doing, and that is not a party we find.
But the party who has filed the writ petition.
No. Some assistant section officer, according to you, is doing something mischievous, right? Is he a party in the petition? Please see 1 to 6, respondents 1 to 6.
Yes, my lord.
Which respondent?
Yes.
Where is the culprit as a post respondent, pleaded as respondent? Right. That person culprit will be repeated. He said assistant section officer has done it. That is what state this person. And the already exam reopening the yes. Directly register to then. Yes.
I'll make good my case in 2 ways, my lord. First, let the office objection be overruled. If the office objection is sustainable according to your lordship, I have no case. What the office objection says is, as I understand, that there is no public interest involved. My lord, your lordship would kindly go through the affidavit.
So you say
contents.
public interest is involved.
My lord,
You say public interest is involved.
yes, my lord, it's a large scale leakage of examination papers
Ah.
by Telangana Public Service Commission to the detriment of all the participants. My lord, these people who participate in these examinations, they come from downtrodden sections and middle class families. They spend huge amounts towards preparation, and the members of the Public Service Commission themselves are involved in the leakage of the examination papers. Let's say havoc which is caused on the life of several youngsters. Nowadays, my lord, to file a genuine public interest writ petition has become a big problem.
Ah.
The issue is,
Correct.
the issue
Most
is,
of the times we find that it is sponsored.
no, many times what,
No,
many times what,
not in your case, not in your case, but
But,
90% litigation is sponsored
I agree with you.
and by the blackmailers who demand money and don't get it, then they file a petition.
My lord,
Like just now we had a case of an agriculturist.
my lord,
He did not know which crop is sown on his land right away. We asked him, he said, I don't.
in my 30 years of experience in the
What?
bar, at least I never faced this kind of a problem, nor I ever sponsored or appeared for any such
No.
blackmailers.
Arey, Mr. Sharat Kumar, we said not in your case.
No.
We are generally saying.
I do get, that is why I am
Ah,
explaining to you.
because you said
that
we-
it
we
is the
were-
case.
We were not saying anything.
No.
You said that it's a genuine
No.
case. So therefore I said.
Your lordships are 100% correct,
Yeah.
and the statements made by your lordships are also
Yes.
correct. The Supreme Court itself
Supreme
cautioned.
Court has said.
Yes, the Supreme Court itself
It is
cautioned
a
that
publicity interest
Yeah.
litigation.
Yes,
And
busybodies,
not.
busybodies and people.
Paisa interest litigation.
Yes, yes.
Public, this thing, publicity interest
Yes,
litigation,
personal
all this
interest.
personal, you know
All
it.
that is there.
Mr.
My
S.
submission is let the office objection be ruled out, and then, my lord, I'll make good my case. Your lordship would understand whether there is any public interest involved. Even
no.
after that also, if your lordship comes to a conclusion that there is no public interest involved, my lord, your lordships are aware there is a rule which says that for abusing this forum, the petitioner is liable for punishment by way of awarding costs, etc.
Ah, yes.
So I am prepared for that.
All right.
The only thing is that a public examination, my lord, which involves the lives of hundreds and thousands of people,
Fine.
cannot be conducted in
All right,
such a
Mr.
hazardous
S.
manner.
Permit us to dictate order, Mr. S. Sharat Kumar, learned counsel for the petitioner.
Ma'am,
Huh?
request, my lord, with your lordship.
It's on office objection. You can't have any say.
Yes.
Yes.
S.
Response
Mr.
to-
S. Huh? Yes.
Because a similar relief has been paid in the writ petition, my lord, that
But it's a
Which
public
petition?
7725 of 2000,
Connect it. WP number
7725 of 2023, my lord, before
double
it's under
seven
single
two
judge,
two one.
2023.
Ah.
Before
So how it is before single judge and how this
Well,
is
the
for-
relief paid is for to use the CBI, the investigation, my lord.
before single judge?
Before, the same relief has been
You
paid.
make an application, then you are respondent. You are respondents in both the petitions.
Yes. And in 4 status reports are also filed in respect of the investigation.
In this writ petition filed as public interest litigation, the petitioner who claims himself to be a public interest, to be a public spirited individual, seeks a direction to declare the memo mandamus. Declaring the memo is not, seeks a writ of certiorari for quashing the memo dated 14/3/2023 on the ground that the same is arbitrary and illegal, and full stop. The petitioner in addition seeks a direction to SIT to hand over the investigation, hand over the entire investigation pertaining to leak.
Examinations for the assistant engineers. Group 1, Group 1 and
Group 1
yes.
assistant engineers. Group 1 assistant engineers exam.
Group 1 and assistant engineers is separate.
Acha, Group 1 and assistant engineers exam.
The last
One
resort
minute.
for a citizen is to approach this honorable court.
No, no,
Because the system here is rigged in
Mr.
such a way.
No, Mr. The relief, what we are saying could have been more comprehensive, except directing of CBI. You have not said anything else, right?
I, in the course of
See, oh, so and so direction to CBI. Will stop after hearing learned counsel for the. Mr. What about this thing?
the second one is
No. You should think of this thing. Impleading respond number 6 by name.
I, I, I,
If you have taken a particular ground.
yes.
So learned counsel for before three learned counsel for the petitioner is at liberty to praise for and is granted time to enable him to implead respondent number 6 in personal capacity. Right? Got it, Mr. Sharad Kumar?
Yes, sir. I,
You should do so.
yes,
Because you are saying that he has been convicted by this court.
yes.
What?
Yes.
Except from filing genuine petition, you should have to do all this also, right? Except telling the court it's a genuine thing, I never did it. But you, next. Yes.
Lord, this is a case, my lord,
Ah,
where this honorable court,
non-compliance of the orders of a court, whether a PIL can be filed to which you are not party.
Lord,
Please, if you are ready on this point, then argue. Otherwise, you may take time. We would like to know. We would like you to hear from this, except saying that I have 30 years and all that. If you are ready with case law, then please say.
Lord, I'll just make good in 2 minutes. It doesn't take much time also.
No.
Lord, first of all,
So we will not do the research work for you to hold.
Absolutely.
Are you ready on this point?
yes,
Ready?
yes.
Fine.
The question here is, my lord, the office objection should be on the basis of the facts pleaded in the writ petition. Your lordship would agree with me at least on this point.
What is
Whether
the
the
office?
adjudication, whether there is public interest involved or not,
Ah,
all matters to be
to be
considered by
dealt
the
with
law.
by the. Fine. Yes.
So my
After
submission is
hearing,
registry
but
cannot-
are you ready on merits or you are only ready on office objection? We were going a step further by asking you a question on merits.
Let the office objection be overruled and put up any day convenient to your lordship. I'll argue on merits.
You should have said that yes.
Because
After hearing learned counsel for the petitioner, office objection is overruled. Please move a memo, do something, right?
Yeah.
Huh? You are a public interest, this thing,
So,
activist. So he has to be vigilant.
I was on that side of the fence also, the special government,
Okay.
this side, that so many
Do
people.
it anytime you are ready,
Yes,
please.
problem.
Ah, 77. Same password.
For the respondent.
Ah, yeah, we know that password. That's why petitioner is not appearing.
I'm grateful.
It's the end of the list.
End of the list. All password at the end of after 153. Yes. Ah. Nobody is there. Password.
Kindly have this matter on 12/9, your lordship. Connected CRP is also posted on 12/9.
2354. 2354. So what date it is posted to?
12/9, your lordship. The connected CRP is posted.
12/9.
In this petition under Article 227 of the Constitution of India, the petitioner has assailed the validity of the order dated number.
I apologize.
There's no reason, right? In 1843, you are saying this be taken up with 1843. With CRP.
2354 of 2020.
In this case, my lord, I
May I
am appearing for the
please-
second respondent, my lord. On my behalf, my lord, senior counsel Sudarshan Reddy is appearing, my lord. He requested pass over, my lord. He ended up in traffic jam, my lord.
Let's
So this is condonation delay.
There is
I have-
500, for 5 years delay, my lord. That's me kindly pass it over.
Have you filed objections?
Yes, my lord. I filed a counter after draft.
No, this counter to this condonation delay and all.
Yeah, you have filed a
Kindly pass over, my lord. I filed a
Satyam Reddy. Have you
Let's have
filed a
prepared
counter?
a brief synopsis, my lords, in the matter.
No, they have this notice that you have prepared synopsis, so that's why he is seeking a passover, senior counsel. Huh? Who told you that you have prepared a synopsis? Who told them?
That's IA. Who is concerned, my lords, there is a delay in representation of the.
All right. Passover then he said.
Very well.
Yes, next matter. 80. Passover means you have to argue, Mr. Whosoever was there. Right. Passover means, I mean, not to be adjourned in Passover round. Cases which are being passed over, they have to be argued. It's not a fun, right? Getting a Passover, then seeking adjournment. We are telling everyone. Yes.
May it please your lordship. My lord, I beg to appear, my lord. I beg to appear for the appellants before your lordship,
Yes.
my lord. There's a short list of dates. I can't call it short, my lord. A list of dates because the record is quite, my lord, bulky.
No.
Lordships have been pleased to issue notice on 18/7/2023
I didn't get the notice.
pending admission.
Okay. Okay. Hmm. Yes, yes.
May it please your lordships.
Huh?
My lord, this appeal arises from the order of the learned single judge, my lord, who has been pleased to dismiss the petition. My lord, the writ as originally filed was only A, for a limited purpose, and two, my lord, against the action which was threatened at the hands of the Telangana State IIC, my lord, Investment and Infrastructure Corporation. So if your lordship will oblige me by having page 87, at 88,
So, this is what, like, notice has been issued, right?
notice has been issued.
Who appears for respondents?
My lord, they were appearing on caveat.
Ready? So what is to be done today, Mr. Rawal?
My lord, I'm ready, my lord. I can either argue it finally or for interim orders, my lord. I'm in your lordship's hand, my lord.
Ready?
Respondents, we are updating.
Huh?
We are the owners, actual owners of the property.
So you are ready, no? So we can hear the senior counsel, right?
Yes.
All right. At the end of the list, Mr. Rawal, so others don't wait.
As it's
At the end of the list.
Will be
Next.
May I please, your lordship?
Just ask somebody to get this clear. One second. So maybe that itself will.
Yes.
May I please?
Mr.
Item number 81 and 82 go together. I
yes.
prepared a small note with the permission of my lord.
Yes.
May I just pass on a note? The grievance of
You are not an employee of the government who accepted, like, signed on dotted lines. Central Inland Water Corporation, not the position. You people have accepted the terms and conditions with eyes open, and
Yes,
that's why learned Singhal just says that you can't challenge turnaround.
It's my.
Who are you? Judicial officers or what?
I'm individual, sir. The first petitioner in one of the matters is an advocate. They were appointed in terms of.
And number two.
Second person is also.
So you were appointed as members of the Commission for Protection of Child Rights, correct?
Yes, they were appointed as members. My humble submission is, under the Act, there is a proviso to Section 20 which says that after the appointment, no terms shall be varied to the disadvantage. GO 5, which was issued, my lord, we consider on page number 37, the relevant rule said that the salaries that will be payable to the members will be on par with the salary that is payable to the principal secretary. In terms of GOMS number 5, that is on page 48, paper notification was issued. Thereafter, they applied and appointment order was issued under GOMS 11. Under GOMS number 11, it was stipulated that the orders with regard to the emoluments will be issued separately. It was never an issue that it is to be fixed or it has to be decided as to what will be the quantum payable. May I draw lordship's kind attention to that particular page, minutes? GO 11, page 60.
It is a straight law.
44.
This is the closure. Subsection 22 deals with the state commission. While section 7 deals with the central government. Here it shows This is in contravention of section 20, right? It's unable to stand. So after they were done, then they listed honorable and instead of salary. This one on the scope and after prescribing and JB. Instead of salary, they prescribe honorable.
All right. Yes.
Yes.
Mark the presence heard on the question of admission. Petitioners who are
delay of 79 days, my lord, sir.
all right. That's condoned. Yes, madam.
Yes.
One more,
You can't oppose the. Do you can't oppose the condonation of delay, right?
Yes. Yes.
So delay IA 1 of 23. So and so condoned. Then dispensed with. That you know 2 of 23 allowed. Then heard on this is admitted. Both 81 80 admitted for year.
Subject to my lord's kind permission, IA3 is for the release of the admitted amount because Honorable Leonard Singh
yes,
has
madam.
granted.
Yes, I have already advised them, my lord, will be.
So heard on IA number so and so. 3 of 2023. Learned. You are what?
For R2, my lord, government pleader, my lord.
Government pleader submits that the admitted amount due to the petitioners shall shortly be paid to them.
Yes.
I'm grateful.
Obliged.
Yes. Next, madam. Next.
Shall we pay to them, subject to the
Admitted amount. Yeah, admitted amount, right? Honorarium has also not been paid.
Honorarium amount for certain period, but their work that is not paid.
But due to the petitioners on account of honorarium which has not been disputed by the respondent number 2 shall be paid to them shortly.
Only admitted amount, my lord.
Only the admitted.
Honorarium, madam.
Yes, yes.
Article 23.
Very well. Very well.
What is state doing like this?
Sorry, my lord, I have already advised
Yes.
them. Yes.
Deeply obliged.
Milord 83, Milord. I'm representing on behalf of Tirupati Gowd Advocate, sir, Milord. I'm representing on behalf.
Okay, yes, go ahead then. Petitioner. Then what?
Milord.
Counter has been filed.
We will file the reply counter, Milord. Kindly 2 days time, 2 weeks time may be granted, Milord.
What, 2 weeks time to do what?
Reply to file reply to the counter.
Petition is admitted for hearing. Learned counsel for the petitioner. Praise warrant is granted. 2 weeks time to enable.
Subject to your lordship's leave, my lord. Because personal notice has been taken out, my lord.
I am appearing for respondent number 1, 3 and 4, my lord.
Yes.
I seek the 3 weeks time
filing the counter.
Ah.
Just I have not received the material papers. I have received wakalat just few days before.
Serve papers on him, extra set, and learned counsel for the petitioner undertakes to supply an extra set of writ petition to whom, Mr. What's, you are appearing for 3.
1, 3 and 4, madam.
Learned counsel for 1, 3 and 4.
Second respondent.
Learned counsel for respondents may file counter to the petition within 4 weeks if thereafter.
Obliged.
Counter, Mr. Praveen Kumar.
Petitioners, my lords. Counter for R1 has been filed, my lords.
Huh?
But,
Mr. Praveen Kumar.
Not in this matter, not last occasion, not the respondent number 9. But the mine safety guard has been indicated.
Counter is not there, Mr. When have you filed?
I'll file, my lord. I'll file that.
Huh?
Last occasion also.
You have filed.
Not filed.
Then say so. How much time?
4 weeks time, my lord.
Learned counsel for respondents. A petition is admitted for hearing 4 weeks. Praise for and is granted. Let counter, if any, on behalf of respondents be filed within 4 weeks.
87.
87, madam.
Matter, my lord. Appearing for the petitioners, my lord.
Shravan Kumar, R2.
Why don't you speak into the mic?
I want to file a counter, my lord. Kindly grant 2
What
weeks time.
counter? Nothing. You appear for who appears for Human Rights Commission? Human Rights Commission. All this has been dealt with by Supreme Court, Mr. There's nothing. What counter will you file? Have you read the judgment of Supreme Court in 2014, volume 15 SCC, page
197.
197? What counter? This all has been interpreted by Supreme Court. What? Why do you do so? What counter? No counter.
Sir.
Correct?
Yes, my lord.
You are not saying anything.
Yes, my lord.
Learned counsel for the, so the one who smiles, we find that we are saying in his favor something. Learned counsel for the petitioner submits that this Telangana State Human Rights Commission Take 2 weeks time to enable him to file rejoinder. IA so and so, IA 3 of 23 shall be considered at the time of hearing of the petition. Yes. Next.
Representing on behalf of petitioner in this matter, it may be taken up on next Wednesday, Lord.
Why next Wednesday?
Senior counsel is appearing in this matter.
Senior counsel, he should be here, right? You sought time to file documents.
Yes,
not
Lord.
doing so. Not filed and seeking today that senior advocate. Then he will, on that date, he will not be well.
No, Lord. Next
What?
Wednesday, Lord.
Don't play hide and seek with the court, mister. You should be fair. You were supposed to file the documents on 1/8/2023. On that ground, the adjournment was sought by senior counsel. Whosoever, Mr. Rohit, you are Mr. Rohit.
No, Your Lordship, I'm junior counsel of Rohit.
Then he himself sought an adjournment to file documents. Today you are telling that it has to be argued by him.
Yes, Lord.
That was utterly casual, right? This all provisions of this PMLA Act have been upheld by Supreme Court. This you must know.
Yes.
Challenging again the virus of these provisions, it's a waste of time and abuse of process of the court once it has been upheld by Supreme Court.
One humble submission, Your Lordship.
Nothing, no humble submission, mister. This all, don't be like. We have always been telling you time of this court is precious. Don't waste it. What is this?
You post on Monday, Lord.
You don't know about the order which has been sought. We adjourned it on 1st of August at your request to file documents. Today you are not even referring to that order and saying something else. Tomorrow on that day you will say that senior counsel from Delhi would come. Another day you will say Bombay will come.
No, Your Lordship, it may be posted on Wednesday.
Nothing,
Friday.
mister. You're not serious about it. We believe no interim order, right? All. Learned counsel for the what's your name?
Vanam Sai Lokesh.
Learned counsel for the petitioner has appeared in compliance of the order dated 1/8/20. Sorry.
Hearing for respondent.
Yes. Yes. Rejoinder, you want to file? Yes, we'll agree to. You want to file how much time?
2 weeks.
Learned petition is admitted for hearing. Learned counsel for petitioner praise friends granted 4 weeks time to enable him to file rejoinder. Yes.
May I please the Lordship? I have filed 2 IAs.
Counter.
It is coming up for counter. And subsequently, when the matter is pending before this honorable court, notices have been ordered. The respondent ought not to have been proceed with the matter, where act is under challenge.
Yes.
Yes, on 24.
Counter, Mr. Advocate
My
General.
lords, I shall, I request your lordships to consider some reasonable time. My lord, I will file the counter, but there are other writ petitions pending also. My lord, I will combine all of them and one lead case, your lordship. 2 weeks, your lordship.
I have filed implead petition, my lord, of the persons who have.
Right, we'll issue notice on implead petition. Right. Third on IA 2 of 2020, issue notice to proposed respondents. Learned Advocate General praise friends granted. How much time, Mr. Advocate General?
My lords, your lordship may consider
3 weeks. 3 weeks time to enable him to file.
IA 3 also. IA 3. I have filed IA 3, my lord, suspending the for seeking suspension of the subsequent due.
Issue notice of IA 2 of 23 to proposed respondents as well as IA 3 of 23 to respondents who are not represented.
Placed, my lords.
Last occasion, your lordship was directed to file counter.
Ah.
Last occasion, your lordship was directed to file counter.
No, they don't want to file counter. What to do? Yeah, excellent case for admission. Petition is admitted for hearing. Nobody is none for respondents.
Let's
Yes.
appear for the second respondent. Let Mr. Vijay Prashant requested some time for filing counter for the second respondent. Standing count.
You must say how much time.
But 3 weeks.
We will ask you to file counter by tomorrow 11 p.m.
3
Some
weeks
time means any time.
3 weeks time I will.
4 weeks time. Huh? So this you are respond number 3.
2.
2. Praise for in a 4 weeks time to enable him to file rejoinder. Counter, sorry.
The petitioner in this matter.
Mr. Yes.
Coming up for
Jan.
counter of the respondent.
Counter.
Lordship, I beg to appear on behalf of the respondent number 2 in this matter, Your Lordship.
Learned counsel for respond number 2. Praise for is granted. 4 weeks time. Admitted for hearing.
Interim order may kindly be extended.
Interim order, if any, shall continue till next date of hearing.
Sorry, kindly password Miller.
No password. You want to file any rejoinder?
Miller. The writ of over Miller.
96. 90s. Contrary to. Yes. All right. So what you want to file counter? Not counter file.
Counter also file.
Yes, all right. Petition is admit. The petitioner has challenged the amendment dated 21/3/2023 to Telangana State Prosecution Service Rules. Service rules for appointment of what appellant for appointment of magistrates.
Prosecution officer.
Appointment of prosecution officers
Section 25, capital A.
under section 25 capital A of the CRPC. Oh,
Challenging the Miller, fifth appointment of respondent Miller.
Respondent
all right, delete. The petitioner in this petition, sorry, yes. In this petition, the petitioner has sought a writ of quo warranto and seeks quashment of appointment of respondent number 5 on the post of director prosecution in the state of Telangana. For admission.
Apology Miller.
No apology. Why apology? You have not committed contempt, right? No apology.
Miller is to hospital Miller, on the way Miller.
On the way, it is admitted. You tell him that I argued so well that court was impressed and has admitted. It's for that this very purpose case is listed, not for final hour. 96 complete petition, right? Issue notice of 96 Mr. IA 2 of 23, 3 of 23 issue notice to propose respondents. Even otherwise, nothing could have been done.
So notice also served Miller, but they are also
Served?
yes, Miller.
Madam, served complete proposed respondents.
Proposed respondent Miller, respondent number 5.
Who is the proposed respondent, Mr.? We thought that petition has filed.
I am the petitioner Miller.
Madam, see that. How? Proof of service not there.
Give me the ID.
No, but then at the time of hearing, then
You filed with me, some others person. Others are filed.
in case others have filed, then we can consider at the time of hearing. Correct.
We can consider.
Then
not
say, IA so and so 1 or 2 of 23, 3 of 23 shall be considered at the time of hearing of the appeal. Next. Yes.
On the last occasion, state has been implemented as party, my lord. On the last occasion, my lord, state has been implemented as party, my lord. I request some time for filing counter, my lord.
Some time means how much? Again,
3 weeks, my lord.
4 weeks time to file counter.
Name is also not printed, my lord. Name is also not printed, GP for revenue, my lord.
GP office, print the name of GP for revenue.
With regard to the same prayer, writ petition 8858 of 2011 also pending.
File an application for linking, we will do it. Very often we have found that those two on an oral prayer we link and then they say that somebody else will say my case is not similar.
He is mentioned in that.
Wait, please, Lord. Wait, please. Cannot be allowed. File the chronological events. And it's just 2 minutes, my lord. My lord, only on 2 grounds this writ appeal is now posted for hearing. The lord have asked me to file chronological events.
Yes. So it has to be heard.
And nomination.
No, yes.
2 points, my lord. Only 2 minutes, my lord.
At the end of motion, we'll take it up. At the end of the list.
File the counter just now. File there are some new facts have been added.
No, but this thing, Mr. What is then we
I have agreed by it, my lord. R5 or R4 is not agreed by it.
What is the interim order operating against you?
Against not to disburse the amounts.
Disburse of 60 lakhs in Malaysia.
Against R3, I have completed the contract.
What is this?
I am ready to-
You are not getting 60 lakhs in any case. Mister, you are not getting 60 lakhs and he is not at flight risk.
Yes.
Not at flight risk. So payment of amount to him will be subject to outcome of the petition that he will restitute the amount to the government. But let him be not deprived. You take own time to file counter everything. No, this not like this is a public interest litigation. You are not getting 60 lakhs. This is public interest.
60
public interest litigation. Please appreciate, Mister.
The hard is that the amount of state group need not be paid to them. They just pay.
Paid to me, my lord. Respondent number 5.
No. The problem is that this interim order has been granted. Thereafter, his predicament is that you are seeking adjournment. Then you are ready. We are also ready today. At the end of motion hearing. At the end of motion hearing, in the meanwhile, you go through whatever respond number 5 has said. We will not take any view against you that you have not filed a counter. The only thing is you don't have to argue anything. He has to justify.
That's correct.
But the contract worth 180 crores has been awarded to him by nomination. Right? That's it. And this is how the Supreme Court has said that the award should be given in the contract should be awarded in a manner known to law. That's it. He has to explain. And
The burden is on me, my lord.
at the end of motion hearing. At the end of the list.
I am great.
Next.
The counter not filed, my lord.
Not filed.
No, we have to file in 2 weeks, my lord.
Learn it.
Only 1%. Counter by R3, 13 is.
Yeah, let counter petition is admitted for hearing. Let counter on behalf of respondents who have not filed the same be filed within a period of 4 weeks. Yes, this week.
Because we are doing yesterday. I wanted to show it to you. We do this. We taken 125 cases and the face. So 100 so we get the people listen to so that automatically it comes the next day. Yeah, yesterday we sat and not the program. We sat here and did that exercise. That's why we are like Mr.
May I please, my lord? Lord, the respondent number 5, my lord, 5 minutes.
Yes.
Lord.
Before respondent number,
I apologize.
report has been filed, my lord.
Earlier, my lord, the lordship has ordered, the lordship has says me to file a
some proper additional,
Additional documents
Lordship,
coming,
Lordship,
additional documents.
Lordship, I filed, my lord. I filed, my lord.
You have filed?
Lordship.
When?
Lord, last week only I filed, my lord.
What is document? What is it?
Lordship, due to delay of filing this PIL, my lord.
Delay?
Additional documents.
PIL itself is not maintained.
Additional document, what is the SR number? We have not got any additional document. When did you file it and what is the SR number?
Lordship.
After 13th July, we have nothing. You are served additional documents?
No, additional documents are not been served, but apart from that,
Is an order of this court where he undertook to file additional documents.
Yes, Lordship.
Has it been filed to at least given to you? We do not have the benefit of those documents.
I have not been given, Lord. I am requesting repeatedly, but my lord, I inquire about that, my lord. I have already filed, my lord. I just have to inquire about that.
SR number, we'll ask the registry to put it up.
Lordship, I'll give you lordship.
You don't have the.
I sorry.
Not the date.
Sorry, my lord.
On 1/8/2023, counsel for the petitioner was granted 2 weeks time to enable him to place on record certain documents. Once again, counsel for the petitioner prays for adjournment to enable him to place. List. We have better things to do than these very cases keep on repeating.
Sorry,
and you appear with us. This man is, we are required to go through your case, and then a lot of human effort is wasted, right? This, it doesn't, this thing. You have not complied with the orders of the court, therefore don't smile. You are mocking the system, right? See that how I am making it run.
Lord, I inquire about
Making a
that.
false statement before the court, we will haul you up, Mr.
Lordship.
That when brother asked what is SR number, you are unable to tell. We are good to you. We could have put everything on record. That he said he has filed. He is unable to tell the date, unable to tell SR number. That means making an incorrect statement.
No, my lord.
What is this? No means what? Then tell what is the date of filing of document and what is SR number.
Lordship, I will just say it.
Don't do it, Mr.
Lordship.
You should have seen it before. We permit this thing mobile. That doesn't mean that you will, when the query is asked, you will search in Google.
I apologize.
What is the answer?
I apologize, my lord. I'll inquire about that, my lord. I'll serve the paper, my lord.
You have this chat GPT thing on mobile. Ask him. Ask it what to do when the office objection court is confronting. Chat GPT will answer for you, right? And you, on subscription, you get it, the app in your mobile, right?
Sure.
So ask, when the court asks about compliance of office objection, what should I do? Chat GPT will answer. Be little more serious, mister. This profession is not meant for persons with casual approach. You are a young man, that's why we are telling you, right? Next. Notice.
Yes, to amend the prayer. Not amended the prayer.
Yes. Not amended the prayer.
Yours
Amended, my lord. Filed today morning.
Today morning.
Yes, my lord.
So can we allow it? What is the amendment you have sought for? Huh?
Amendment prayer is not served on.
In fact, my lord, let a copy of IA seeking amendment of the writ petition be served on learned counsel for 1 to 9.
On R11 also, my lord. It's not served on
R11. Yes, R11. 1 to 10 and 11. 1 to 11. Learned counsel for 1 to 11. Yes. Yes.
Lord. Oblige, my lords.
Yes, Mr.
May I please? I'm appearing for respondent number 2 and
You
3,
want
my
to
lords.
file?
Counter is filed.
No, my lord. We will file counter.
Let counter, if any, on behalf of respondents be filed within a period of 4 weeks.
Much of Lordship, I'm sorry, my lord.
Only that should. It's also the. Result.
Yes.
Lord, I'm sorry.
103.
Lord, a small submission. Lord.
Sober, please wait. Matter is adjourned. Don't disturb the court proceeding. First thing to learn is that.
However, G for medical and health. Counters
Yes.
are filed.
You have conducted an inquiry, right?
Counters filed.
No, fine. But what is the outcome of the inquiry? Who is responsible for the death of this thing, mother and the baby?
The respond number 5 filed counter in this matter.
Arcelor's counter can be as bad as it is.
Who appears?
Telangana.
R8
R7, R8,
and R5 also.
R5.
You appear for whom, Mister?
Respond number
For medical.
1, 2, 4, and 5, 7, 8 million.
1, 2,
4, 5, 7, 8.
So you don't want to file any this thing?
Respond numbers 3, 6, and
No,
7.
we have got it that 5, 7, and 8 have found the counter.
We file
So
counter
should we-
respond number 5.
No, Mister, this is not an invitation extended to you. We will proceed against. I mean, if you don't want to file, or you
5,
say
7,
that,
8 we file counter.
Mister,
I'm sorry.
that we know.
Yes.
Either you are representing some of the respondents who have not filed counter. There can be, according to us, only two courses open to you. Either to say, I don't want to file counter.
Telangana, it is standing calls.
The other thing
Telangana
is
Vaidya Vidhan Parishad.
to adopt the counter filed on behalf of them, or pray for time to, these are the three courses open to you. You are not doing any one of these.
There are other concepts.
You don't want to fight.
This is standing calls with them. That's why I'm not.
Is represented by a standing concept.
There is, I appear
Why
for
are
third
you
respond.
not doing anything?
That's I was.
Please.
Respond number 3. I have also filed this counter.
He has also filed.
No. You
Vaidya Vidhan Parishad.
3, 6, and 7 is also.
So, Mister, what about you now? You don't want to file, right?
It is there.
So he is one and all that.
One is principal.
1, 2, 4, they do not. So sit down, please.
No,
No, don't. This is the level of assistance Mr. granted to us. What can we say about it? And you say equal partners in the administration of justice. This is administration of justice. You don't want to sit down. Please sit down. Sit down. We will go through it and find out.
There is no counter by R1 and R2. Who are the main people who have to address this issue?
We filed adapted petition. Adoption petition we filed.
You have filed.
No, we will file me lot. That's what it is. The incidents occur in the Maubna district. That's why the concerned officers filed the counters. So we are not filed the respond number of statement.
The first place where the deceased went
The respond number
is Achampet.
Amrabad. Respond number 6 Amrabad.
From there to
From there to Nagar Achampet to Nagar Karnool. Thereafter Maubabad.
Where she deceased.
Yes.
Both the newborn as well as the lady at deceased.
This counter doesn't anything.
At the hospital respond number 5.
That is the,
So this 3, 6, and 7 has nothing except narration of incident. Then we will come to 5.
Respond number 5 counter me in detail, Miller.
And 8 are the initial counter.
5, 7, and 8. We'll see what they have said.
Mehboob Nagar counter affidavit is strong.
Respond number 5 Maubabad.
No, Mehboob Nagar.
Respond number 5 Miller.
R5 counter will have R5 ఒకటి వచ్చింది. Medical patient who have been taken. Ultimately,
R4 is the director of public health.
newborn died as well as
She died.
See, Chief, when initial this thing started at 6 o'clock in the evening, and ultimately she got to this place at 2:30 or so. So for 4 hours, 125 kilometers, she needed to run from 3 places. It's not a basic, and at one place they did not have oxygen.
Which places?
The seventh respondent counted at sea. They said we had only two oxygen in our pits, and that is the group, and they were already put to somebody else, so therefore we could not.
So it was on
seven
account of lack of oxygen.
Not oxygen, the beds with oxygen facility. And that is, once you don't have oxygen, you'll get fits.
Lack of beds in this thing.
That is R7 score.
Hmm.
220.
Where not available. Where it was not available, ventilator.
That is R7. This is no.
So where it is safe that this is not available, ventilator.
Yes. And there are available to only to other patients.
Oh, so which place I'm asking?
This is the second before the marriage life, the final before this was during evening.
District hospital, Mahbub.
No, this is this is the district hospital.
Government.
Champir, Champir district.
Okay.
So this itself is a separate district, and they do not have medical facilities.
Which should be asked them to make available medical facility in each of the district.
And there are almost funding allocating to state districts. That did not happen.
I mean, we issue action, those are not right. Yes. Mark, yes. This public interest litigation was registered on the basis of a news item which appeared with regard to death of a mother and her baby. Mother and baby. Full stop. Paragraph. Respondents number 5. Respondents number 3, 5, 6, 7, and 8 have filed counters. Paragraph. Deceased. Paragraph. Deceased Srimati Swarna, aged about 24 years, resident of Yelampalli village, Amrabad Mandal, Nagurkol district, was brought to Community Health Center Amrabad by 108 ambulance with labor pains on 26/12/2022 at about 8:15 p.m. Full stop. See, 8:15 p.m. says 10:30.
This is she was not to find maybe this first she
And
went
then
to fifth. First she went to sixth.
The aforesaid patient was thereafter advised advised to go to higher facility for better treatment. Thereupon, she was brought to area hospital Achampet at around 10:30 p.m. The said patient was admitted in the hospital and was examined in the labor room. Full stop. Paragraph. Thereafter the said patient thereafter the said patient was given treatment and was referred to Government Hospital Nagar Kurnool at 11:15 p.m. by the ambulance. Full stop. The petitioner, the aforesaid patient was given treatment at whatever government hospital, Achampet, Nagar Kurnool, Kurnool, and her Don't, Mr. Stand up and look at us. You are not standing here to tell us that 5, 6 and 7 have filed counter.
Yes.
We could have recorded your this thing also, that standing up for respond number 1, not saying anything, looking at us and telling the court that 5, 6 and 7 have filed counter.
Already, at the starting, I said.
Fine. You did not say. You said 5, 6 and 7 have filed counter.
I'm sorry.
You did not say that I want to file counter. All right.
Sorry, I'm sorry.
You will suffer. Yes. Next.
Counter filed, Milord. R9 counter filed, Milord.
Filed?
Yes, Milord.
Oh.
This is with regard to the fire accident occurred.
Fire accident. Yes, yes. Shocking for people, yeah, died.
But
I'm appealing to respondent 3 and 4, my lord. We filed
Pleadings are complete.
No, my lord. 3 and 4 we filed a counter. It is returned, my lord. We have complied with the objections of the office. Today morning it is numbered.
You have filed today?
Today morning. US are filed.
So all of you have to now suggest, Mr. This is PIL is not an adversarial litigation, Mr.
Yes.
Right? Your friends,
But we have to
everybody, your colleagues should understand. You have to come up with a suggestion.
Yes.
Now what to do to prevent such a this thing incident in future? What this thing, what led to this unfortunate incident and what is required to be done?
Crime
This
has
is
been
what prepare.
Yes, but a crime has been
Learned
registered.
Counsel for respondent number. Praise for it is granted. How much time?
Lordship, I have it on Friday, my lord. Already it's numbered.
How much time?
2 days.
1 week time.
1 week,
to
Lord.
file.
Suggestions you have to come up with.
Come up with
Suggestion.
a
Yes, my lord. Suggestion.
print out,
Yes, my lord.
not like argue.
Along with the memo, we'll file.
7 and 8 wants to, after both of you have given submission, we will hear arguments of 7 and 8.
7, 8, 8, 5 lots. We have filed.
If you have filed, be happy. We are granting time only to the one who has not filed.
Yes.
Yes. 105.
Lordships, kindly pass out this matter.
What, madam? Pass over. Wait.
Proceedings have been completed.
Why? This again short adjournment to enable him to prepare. You are not ready, it appears. Interlocutory direction petition. It has been admitted.
Counsel is filed and reply of the filed.
Rule 95 has been issued 31/8. The petition has already been admitted for hearing on 31/8/2023. Let the same be listed for hearing in due course.
2023. Yes. 106 to 109.
106 to 19, 109.
Yes, my lord.
Yes.
It's an I filed expedite petition, my lordship. I have filed expedite petition, my lord.
What expedite petition?
To, in this, my lord, they have already filed the counter. This is a matter relating to the NCC certificate, my lordship. I have filed, the respondents have already filed the counter and I have filed the reply, also the synopsis also, my lordships. Your lordship may fix
This
that.
is 23 petition, madam.
But it relates to recruitment of police constables, my lordship.
What happens? The police constables will be recruited. Police constables will be recruited.
My lord, the results are going to be declared, my lord. If the results are declared, my lord, these people, the very purpose of filing the petition will become infructuous, my lord. We are seeking under NCCC category, my lordships. And if the results are declared again, fresh litigation will arise, my lord, because these people.
Why? No. List pendants. Everybody selected is subject to result of the petition. They will be bound by it. We will say so. that the whosoever is selected will be bound by the result of this litigation.
My lord, if there is
They
no.
will be bound.
Yes,
No
my lord.
multiplicity. Why would successful candidate file a petition here? Only those who don't succeed file come here.
Yes, my lord. Now, my lord, there is no order as such as your lordship has stated, my lord. If now the respondents may take a plea that there is no order as such.
C, A, B, C. It will be usually we have to decide the application for a year. That can be they find a part.
How much time you will take, me?
I will take only 15 minutes, my lord, not more than that.
Depending upon that only we will fix it. If you have a case, you don't need to argue more than 10 minutes.
Yes, my lord.
Those counsel, our impression is, we are telling you a secret. Those who tend to this thing, longish arguments have no case.
Yes.
Because we are telling you a secret.
Yes, I
Because initially judges are receptive initially for 5 minutes, thereafter they relax and allow the counsels. If you have a case, conclude in 10 minutes.
Yes, I'll take 10 minutes, my lordships.
Madam, why have you challenged? Why have you not challenged this notification when you have applied? This condition was there when notification was issued.
Yes, my lord.
Why did you not challenge them? Why did you wait till the results are declared? And today coming before the court and saying they are going to declare the results. Why was it not?
So we will maybe we take up your petition after the Constitution bench answers this. Manjushri and all other case law, whether it is open for the petitioner to challenge the process after having participated. There are judgments against you, but we will not dismiss this today because it is referred to a larger bench.
Yes,
of Constitution bench of Supreme Court, whether a candidate. So answer my lord's query. What were you doing?
My lord, some other.
Why you did not challenge?
My lord,
you learned that you won't be selected, so file a petition.
My lord, some other persons has already filed at the time of notification.
Madam, item number 107 in 1 minute. What? This is all your. This is extraordinary discretionary jurisdiction under Article 226. Conduct matters. Conduct of fence sitting matters.
107.
Fence sitting. Why you did not challenge? You want an early hearing right away?
No,
Give
my
me
lord,
grant. Argue.
My lord, in this, my lord, the my lord,
Yes. So argue just now.
The petitioner has already made a representation, my lord, to the respondents.
See the time. 1:50 it's over. Yes. 12:50. Sorry. So first answer the first query. Why you did not challenge the notification issued in 2022 and why did you participate?
My lord, I made a representations to the respondent, my lord, to consider my certificate, my lord, to give preference to the NCCC category, my lord, but they did not give any response to that, my lord. And as they have not given any reply, I filed a writ petition, my lordships.
Therefore, you participated in the process.
Yes, my lordships. Yes, my lord.
When did you give representation?
Dates, madam. Where is synopsis? You said ready.
Yes, my lord.
Where is?
Please give the synopsis.
My lord, that please. Your lordship has stated that I won't hear your matter. Just I'll fix a date.
No, madam, you said synopsis is ready just now.
I have filed, my lord.
We don't think you have such a short memory.
No, my lord.
Just now, 2 minutes ago, you said synopsis is ready. Give it.
I have already filed in the court.
Yes. Yes.
My lord. My synopsis, my lord.
Don't read it. It's for us. You argue submissions. Synopsis is for us because we have to write facts.
My lord,
don't read it.
The respondents has issued, my lord, notification, my lord, on 26/4/2012.
April 2022 is the notification.
Notification, my lord.
Yes.
In this notification, my lord, the respondents has
Please go to exhibit the notification terms and conditions.
Yes. Terms and
Go to page 21.
21 is.
Page 21, class 24.
Yes, my lord.
Subclass
Page
1.
21. Yes, my lord.
Subclass 1.
Candidate. Yes, my lord. Candidates who have,
Who possess
who
NCCC
it's
A, B, C certificate issued by competent authority are equally eligible.
Yes, my
This
lord.
is the challenge.
Yes, my
Why
lord.
have you not challenged in 2022 April, and why have you taken part in the exam? In fact, I have dealt with this issue in one of the matter argued by Mr. Ramesh.
Yes,
That
ma'am.
batch.
Yes.
Ah,
But
same women and child welfare.
But for that, my lord, my submission is, my lord, that I made a representation, my lord. but-
Please tell us that. Where is the representation?
Let her say anything. She wants to be a 10 minutes. Then
I
we
request
will
your
start
lordship,
time. Yes.
My lord, in
Not ready, madam.
1041, there is a representation, my lord.
No, in your case, madam, please.
1041, my lord.
That's a separate case. That is his case.
My case, my lord. 1041 is my case, my lord.
1041. Please
Yes.
tell us the page.
Which
Page number is, my lord, 46, my lordship.
Page number 46.
Yes, my lord.
Representation at page
46, yes,
46. Let us see what have you stated. That is what date?
No, we have denied that we have.
My lord, it is 10/12/2022, my
How
lord.
did you give it? How did you send it? Hand delivery by post or whatever?
By
it is?
hand only, my lord.
Where is the acknowledgement?
Acknowledgement.
Where is the acknowledgement of receipt? When it is denied by them in the counter, where is the acknowledgement?
All right, fine. That no acknowledgement. Next.
Next is, my lord, in the year 2015 notification, my lord, up to 2015 notification, my lord, the NCCC certificate holders were used to give preference, my lordship.
You have participated in the process of recruitment, correct?
My lordships.
Participated in the process of recruitment.
Yes, my lord.
When it was concluded?
When was the exam held?
Exam held.
Examination was held, my lord.
28.
Huh? 28/8. 22. When this petition have been filed in 23? Huh? What were you doing from 28/8 till 23? January to 7th January 23. No explanation, right? Fine. That's it. Anything else, madam?
My only submission.
Anything else?
No, my lord, only one submission, my lord, that is up to 2015 notification, the NCCC certificate holders were given preference.
Yes.
And when it has come to the present notification, my lord,
They have not given preference.
That is my contention, my lord, that is the illegality.
Fine. So once preference is granted, it in perpetuity it should continue. That is the submission. They can't withdraw. Yes, Mr. That's what she says. Yes.
So in 2018 notification, my lord, we have the same rule is applied.
2018 notification.
For 18 notification under GMS number 49, my lord, rule was
No,
amended.
but what is the justification?
No, so
What is there has to be justification
No,
for
this-
equating NCC, ABC certificate holders.
the candidates, my lord, the intermediate is a qualification for police constables, my lord. By that time, my lord, C certificate holders may not be there in.
Intermediate.
Intermediate
That is the ground.
eligibility.
That's the ground. So there has to be justification. Sitting participating. Closing dispute after taking so that's it, Mr. Anything else, madam? Yes.
My lord, to get an NCCC certificate, it's more difficult when compared to P, my lord. Now,
Yes.
to 15 they have.
See, simple thing. NCCC certificate eligibility will come in when graduation. Forget about, see, once you are, what is the basic qualification? Merely because you have completed graduation and you got NCC certificate, today you are saying when the eligibility is the intermediate for this thing. So what will I get, either A certificate or B certificate?
But my submission is not that.
Anything, yes. So we have
It's not
understood,
that
madam.
lot.
We have understood, just we have understood 2015 till this date, it was there. And therefore, the action of dispensing with such a qualification is arbitrary. And you are entitled to be selected. We should issue an order of appointment to you in a sealed envelope. This is the next submission, correct? Mark the presence, arguments, everybody's presence, arguments heard, case is reserved for delivery of judgment.
My lords, 107 minutes. Because
Anything else you want to say?
petitioner filed the representation on 13/6/2022, even before the just after vacation. And it's on page number 57 and 58.
No, we want to assure you that we will be dealing with the validity of this, not this, that no representation submitted, therefore dismissed, not like that.
That's one of the points which.
Points you have submitted representation.
And the second one.
What is the challenge to validity of the rule?
The second one is, Millards. The page number 17, Millards. The central government has passed the circulated the memo to the state's chief secretaries.
Yes, circular.
So page number 17, sir.
Yes.
And specifically 18 page, my lord.
18.
This is to the chief secretaries of all states and UTs. Where, my lords, the NCC cadets are imparted basic military and weapon training by the service officers of the armed forces.
Which is that?
Page number 18, my lord. This is the memorandum sent by the Ministry of Home Affairs.
Advice.
All the chief secretaries.
Dated.
20th April 24, 2020. 20th April 2020.
2020 minutes. This is prior to 2 years of the publishing of the notification period. And wherein, Millards.
So therefore, you say that this qualification is contrary to 20th April 20.
My friend conveniently arguing, because I mean, I believe it is the relevant to submit in MS, in meritorious sports persons. This international and multinational, they argued that in different way. But no, international and multinational intermediate candidates cannot participate into the international and multinational. So therefore, my friend is conveniently arguing in this case. That's the relevant the portion that no intermediate and all. But whereas there are instances where even MTech and PhD candidates are participating. And this is intermediate classmates.
1 second, Mr. Ramesh. When intermediate is eligibility, everybody should be taken on that basis merely because you possess MBA or a doctorate and applying for a constable, and if you have got a higher certificate, if you are given, then you are treating unequals. You are creating inequality between.
I kindly see this, Millards. The Millards, a copy of this Millards here. Millards, page number 8 itself, Millards. The NCC certificate, the central government suggestion is 5% of maximum marks for the C candidate, and B certificate 3% for the.
That is, I'll put it this way. For let us say for PG admission, I'm just giving an example. PG admission, graduation is the eligibility. So today I may not have taken part in NCC in my graduation, but I have a B certificate because intermediate I have taken part. So I am giving 3%, 3% of the mark. Whereas somebody who has also taken part in graduation, he will be get 5%. But the basis is graduation. So where everybody is treated equally. Unlike the recruitment here, that is why we wanted to hear from him what is the eligibility criteria, intermediate. So let us say somebody who stopped after pursuing education after intermediate will only have a B certificate. He will not have a C certificate because C certificate is only obtained in after you join graduation.
Yes.
So once the basis minimum eligibility criteria is intermediate, the other benefit also should be frozen at that level. You can't increase it and say I should be given preference.
Then my lords, the 107 is the candidates of the B certificate. So B certificate, as your lordship mentioned, they acquired it in the intermediate itself. That is the qualification prescribed by the board.
My lord, I have filed in my writ also, my lord, 1041.
One
Your lordship
second,
may
madam.
kindly.
That's it, Mr.
Miller,
That's it.
I submitted last one, Miller.
Ah.
The 107, the 108 Millers.
Ah.
I mean, 107, the petitioners are B certificate holders and they acquired the certificate in the intermediate qualification that is prescribed by the board. So therefore, they are very much eligible as per your lordship's
But if you are eligible, the benefit will go to you. It's her case, that C certificate.
Right.
Fine.
But this is B certificate and B certificate has a,
Thank
my prayer is in two
Yes.
two parts.
Yes.
One is either to follow the directions of the central government by providing the incentive in the marks or give priority to the C over B and B over A. So that is alternatively this one.
Yes.
So therefore the 107, the item number is the B petitioners, I mean B holders. So therefore they are entitled to get this benefit from the central.
We'll consider. Thank you.
My lord, one final submission, my lord, is
Yes.
1041, my lord, I have filed that certificate of the government, my lord, Ministry of Home Affairs, at page number 49. This may be taken into consideration, my lord, when passing the orders. That is the only submission, my lordship.
All right. See, madam, it could not have been faster than this, right? Application for early hearing filed, heard and reserved for orders. Dispensation of justice can't be faster than this. We have come to the stage of mentioning also where people mention and we pass the orders. Thank you. Thank you.
I record my friend's statement that which is qualification, it is not matching with the qualification. My lord. That may be used for the unemployed within the.
Nothing turns upon, he's saying that we decide, we will decide. Scope of judicial, we will decide about scope of judicial review in a matter of qualification prescribed by the recruiting agency and test it on the touchstone of Article 14 and answer the question, right? Nothing turns upon his saying or anybody's saying.
But that statement that made by my friend is.
What statement?
It is a criteria, everything is prescribed. His saying will not alter. Correct? So we will take that, what is the.
We will examine it and answer it on merits. At the most, what is he doing is he is supporting you. We will record it that he has supported the case of the petitioner. That's it. Okay. All right. We'll consider that. Thank you. Yes, next, madam.
For respondent number 1 and 2, you will kindly 2 weeks may be granted for filing counter.
The petition counter has to be filed. This WA. Yes, so leave is granted, right? Yes, Mr. Stay is already granted. Who is there?
I am for the petition.
3 to 5, Lord.
I am for respondent number 1 and 2, Milord. Kindly post after 2 weeks for filing counter.
Learned counsel for respondent 1 and 2 praise fund is granted 3 weeks time to enable him to file counter to IA 3 of 20. Interim order shall continue.
All right.
Yes, please.
I am for the petitioner, my lord.
Lord, I appeal for the respondent number 5.
You give it to me, madam. Doesn't look.
They are unable. Circumstances over. It's a good gesture on your part. We used to sit here. This why distance is less.
Yes.
I appeal for the respondent number 5.
So what is you file review if your grievance survives? Who is for the petitioner?
I am for the petitioner, my lord.
Then
Can you have it on next week? Maybe posted, my
not
lord?
next week. The
Because of my
crops have been allotted to the
Prayer is to dispose of the representation, Lord. It has been disposed of.
Ah.
Prayer is only to consider representation, it has been considered.
Considered when?
Milord, we have allotted 32 shops to the Milord
Paragraph
members of
3.
the society.
Fine.
Yes.
That's what is recorded in para 3, Mr. In case incorrect factual submission. No, then no next week. Review. If you are agreed by this order passed by learned single judge,
any short
file a review. No, not short thing.
The right to street venue is cannot be taken out. So guaranteed.
No, but this thing representation we will decide. When have you decided representation?
Short password, my lord. My serial
That
comes
one
in.
Depends. But at earlier occasion, my lord, orally I submitted all the, my lord, the copies also. my
No,
lord.
no, no. Representation, date of
My lord, I
decision.
will, my lord, by next date of hearing your lordship's permit, my lord, I will give the list, my lord. List,
List?
entire list, my lord.
Not
For
list.
32 members.
Not
No,
30.
we are not interested. Shops not being.
Arey,
Their
Mr.
right
His
is to do street
grievances, not no decision taken on representation dated 6/1/23. He says, GP says it has been decided. You don't know the date.
My lord, after, my lord, date is not there, my lord, but after, my lord, representation, my lord, we
Learned
consent
Council for Learned Council for Municipality Tupran is directed to disclose on affidavit as to on what date the representation. Within a period of 10 days, list thereafter. That's what he is standing for. Simple thing, mister. You could have asked. You people behave as if we are living in 18th century. Modern days of communication, today itself you can find out you people behave as if we are living in 18th century and it is southern pole, this place where your client is situated in southern pole of the earth. What can be done?
Well, one submission extension may be given.
Interim order granted. How do you know interim order? When you don't know anything about the case?
Only
How do you know interim order is operating?
But I was taking instruction from my senior only.
Nothing, no instructions, mister. Don't come to this court for continuation of interim order. Don't come. We want young people to be ready with cases and to argue. Got it? Interim order, if any, shall continue. You also don't know interim order is there or not because you have not read anything. Huh? We assure you that if you read the file, you will not get a viral fever. Assure you. 100%. It works, you find it.
My lord, Mr. Roy Reddy requested tomorrow, my lord, is not well.
No. Maintenance charges have already been paid. Now counter. None, not admitted for hearing. Counter, if any, on behalf of respondents be filed within 4 weeks. Yes, please. Counter. No, counter is available.
Connected matters are posted to 24th August, your lordship. The
Counter, anybody want?
counters already filed and the connected matters.
Counter filed. Who has filed?
The response.
Not got any counter in this one.
There is no counter matter. When it has been filed, you filed. Who filed the counter?
Lordship senior is online, your lordship.
My lord.
M. Vidya sir.
Ah.
Yes. Vidya sir. Vidya sir.
Yes, mister. Probably you are on mute. You have
My lord,
unmute yourself.
My lord, 113 and 115 learned Advocate General AP is appearing in this matter, my lord. And in 114, my lord, Mr. Mohan Reddy Senior Counsel is appearing.
Counter affidavit. Counter affidavit on behalf of respondents 1 to 5 has been filed. Petition is therefore admitted for hearing.
24th August connected matters are there, your lordship.
We don't.
Not connected, my lord. They are not.
Yes.
They are not connected, my lord. In fact, this request
They is not connected.
They are not connected, my lord. They are not connected.
The two states blood funds has to be blood set it.
In fact, this
100% where it is coming upon 24, where Mr. Vaidyanathan Senior Counsel is not appearing in that case.
That's different.
No, that exactly I would like to just not state so that my friend will also not address for it.
No, we have counter has been pleadings are complete. We have admitted it. If you want early hearing, file it. An application for early hearing. Same way.
As far as the disputes with regards to not bifurcation, as well as not the power bills which has to be not paid. Interlinked.
No, you are not the petitioner.
No, I am not second and third slot.
Petitioner. So we have admitted your petition. Why are you arguing?
24, not so that
You don't want admission. No. So you don't want that matter also to be heard on 24th by creating so much of confusion that, right? No, file an application for linking by assigning reasons so that everybody has a notice. Oral submission, she may be taken aback. that file on 24/8 not before us. How can we this?
Assets and liabilities are distributed. Even this liability will also be distributed.
If assets and liabilities of the transco are distributed between both the parties, both the states, this liability will also be a part of that. There need not be a separate adjudication. You both of you sit and divide your assets and liabilities. That you don't do. One comes before this court saying, I have to get 6,000 crores. The other one comes before this court and says, I have to get employees trust fund funds. Without doing the basic, what is required, you see, in another 6 months or 7 months down the line, it will be 10 years. We will only be celebrating without any distribution of the asset. And central government is laughing because they have a big brother role to make both of you sit and distribute. This is what, in fact, in one of the matters we have held, where I am a member of the bench. But in spite of that, nothing is being done.
That's admitted for hearing. Admitted for hearing. Yes, counter 5. Yes.
114 and 115.
115. Next, madam.
13, 14 and 15.
Yes, we have admitted.
Obliged.
Yes. You want to file anybody rejoinder?
116, your lordship. Respond number 3, we are filing counter today, your lordship.
Learned counsel for respond number 3 submits that the counter shall be filed during the course of the day. Petition is admitted for hearing. Let rejoinder, if any, rejoinder stroke reply, if any, to the counter be filed within a period of 4 weeks. Yes.
Second respondent, we have filed the counter, madam.
Fine.
Obliged.
Next.
Obliged.
Admit.
Matter, my lord, only first respondent filed counter.
Petition is admitted for hearing. Rejoinder, if any, on.
Hearing in item 118.
So you want to file any rejoinder? No. All right. Admitted, this for admission, admitted for hearing. File.
Lordship's indulgence for it.
No, just now you saw NCC candidate, she filed application for early hearing, instant justice, like instant hearing. All cases can't be heard, like in admission stage.
6 to 10%.
Enhancement from 6 to 10%.
Correct.
Covered by 6 judgments of the honor.
All right. You say, you are at liberty to move an application. Give it, madam. 15. 106. Which is the judgment?
118.
118. 118. In this petition, yes. You are at liberty to file an application for early hearing. That's what we told just now. In this writ petition, the petitioner inter alia has assailed the inter alia seeks quashment. Two 273 as well as
MR Balaji versus State of Mysore.
State of Mysore
1963 supplementary 1 SCR 439.
439, right? This is AIR 63 also is the citation.
Then
we have read from, all of us must have read from AIR this thing.
Chebrolu Leela Prasad.
Fine, enough.
Counter is filed.
Admitted for hearing. You filed an application. Madam, prima facie submission appears to be correct.
They filed a count.
So you
But we have to
find
file
out.
counter, your lordship.
They rely upon the EWS judgment. It's against them only.
Yes. Okay. Interesting thing, right? Both councils are relying on the same judgment, so court has to find out what is the ratio. Interesting. All right.
Come up with an application.
Yes, yes, please. Next. Hmm. Nobody is there.
Yes. It's whatever.
All the three.
Record. Record is there.
Batch of
Uh-huh. Yes. 24 to 2023 order indicates your everything describes in detail.
Now, let's appeal.
Action adjudicating authority has initiated action beyond the statutory period 180 days. That's why there is a stay of further proceeding.
They are taking shelter under the extension of orders passed by the Honorable Supreme Court during pandemic. Now, Supreme Court, Honorable Supreme Court in Kasi's case, which is part of record 128, I am appearing. Where Supreme Court has held that this extension cannot be given for the provisions under 167(2) of the CRPC. CRPC 167.
Which is the judgment?
128.
Item 128.
128. Mr. Yes.
So, the initial limit under section 5, the order stands valid only for a period of 180 days. Within 180 days, the adjudicating authority under section 8 has to pass an order to continue the section 5 order, or it can close the proceedings. Now, they have passed the order after expiry of 180 days, taking shelter under the orders passed by the Honorable Supreme. My submission is that the Honorable
Order doesn't apply to the proceeding under PMLA Act.
because 180 day, it becomes
Mr.
honest in the eye of law. And learned single judge has taken the view that I'm sorry, but
So please.
in similar circumstances has taken the view that the extension granted by the Honorable Apex Court can be abide by the statutory authorities under this act. That's the order of the single judge. Determines are filed their pending matters. So for the judgment to last locality 278 years.
Well, the appeals are already filed, no? They are
78.
lots may, so just.
All right. So with reference to this, you are saying that it doesn't apply to proceeding under PMLA Act, right? Learned senior counsel for the petitioner. Or in this, mark everybody.
the PML authority does not have jurisdiction to pass an order itself. My case is not for 180 days. So my request is to de-link the case with the batch and place for hearing.
What has happened in your case? Notice has been issued, not?
Notice has been, contra has been filed, my lord. It can be taken for hearing. Item number 120, my lords.
121 party in person
120.
submits that this
120. 121.
120.
120.
45761.
Yeah, 45761.
What is the case? I mean, how it is linked with these
Yeah, my
petitions?
lords.
No, how it is
Yeah.
linked? Is it under an order of the court?
Yeah, yes, is the order of the court.
Linking is under an order of the
Yeah,
court.
yes, my lord. Yes, my
Then orally it can't be dealing, make an application. This order is, madam, you are appearing in which case, senior? 128. This order is 128, remaining cases list along with 120.
Yes, I mean,
You file an application for delinking by assigning results. If there is a judicial order, by oral submission, we cannot delink.
Please, my lord.
They need to know why you want delinking, not like this.
Much obliged.
I beg to represent Mr. Deepak.
Oh, yes.
My lords, I seek time for filing a reply. The private respondent's count has been served.
There is an order on 6/1/23 that it should come before DB2. So it has to go before division bench.
I leave it to your lordship. No, my lords, that time, because the then presiding Chief Justice of the court, I think was party to taking this decision.
Learned Senior Counsel for respond number 3 and 4 submits that he has filed counter today in view of aforesaid submission. Learned Senior Counsel for the petitioner, praise fund is granted.
2 weeks.
2 weeks time to enable him to file reply stroke rejoinder.
Right.
Oh, yes, Mr. Words of appreciation recorded for you in the previous order. We hope that you will stand up to this thing. Please place it on record.
But I have placed the GOs before the division bench earlier, the matter was being heard. But I'll place it, but I'll place the
subsequent events.
Yes.
Learned Mr. Harinder Prasad, Learned Senior Counsel, representing the Advocate General.
Yes.
Whatever. Praise warrant is granted. How much time?
In 1 week to 1 week.
A week's time to enable him to place on record subsequent events which have taken place after filing of the writ petition. List after 1 week. It can be closed.
I wanted to clarify one subject. Wanted to clarify one thing.
Yes,
There was an order of the division bench. We're not considering the GOs passed by the state, allotting sanctioning amount of 90 crores. We're not multi-level parking the High Court.
Yes, yes.
But this was subject matter of a decision before, I'm told, not a building committee.
No, all of us, you should tell us, I mean, consider the utility of multi-level parking.
Yes.
We are told, I mean, that it's in Delhi High Court. It's available multi-level, but not used. Because nobody has time to park the vehicle on the 9th floor, then to come back. Mr. Any counsel from Delhi who is present can share his experience. You, all of you should consider this.
The state, my lord, while considering the
So what,
the
what
directions issued, my lord, and also the
amount has been sanctioned, 90 crores. Yes.
at that stage, my lord, I am told, my lord, there was some reservation because it's a heritage building, subject matter of the High Court. That's how, my lord, that's how.
Denotified, I am told.
It is denotified, division bench has recorded, my lord. I have an order.
So please place all those documents on
I will place.
list after 1 week.
So that once it is denotified,
Oh, I mean,
That's how the maternity nursing home shifted there. That's how the.
yes, yes, next.
Hearing on behalf of the
Counter.
request the backup will be taken up tomorrow.
Counter.
Tomorrow, my lord, after tomorrow.
Okay. NCC candidate.
So this is with regard.
You are also, it's just now it is heard NCC, you are same category?
No, your lord. You are challenging.
Different case, man. This is with regard to software admin.
this is adventure. You are involved in adventure sailing.
Yes, sir.
Counter has to be filed. Petition is admitted for. Counter? Yes. What is the stay? Why? Mr. Prabhakar Rao is not available. Let IA 2 of 23 be listed for consideration day after. What day after is what? Friday. Friday. What date, madam? Put the date. Yes. 18th. He prays for adjournment, right? On the ground that arguing counsel is not available, therefore list so and so for consideration on that. Yes. Yes.
Surface.
Surface.
It's a matter, my lord, arising out of the surface proceedings. I think your lordships are.
We have taken a view, it's concluded. I mean, we really appreciate, we are bound by our view until Supreme Court.
That is the reason I am allowed without troubling your lordship, my lord, I will withdraw
Thank you so much.
I will withdraw the writ petition, give the liberty to pursue the matter under 70.
Yes, learned senior counsel for the petitioner seeks leave of this court to withdraw the writ petition with the liberty to pursue the remedy of appeal
under section 17 of this.
appeal under section 17 of the SURFACE Write the Whole Thing Act 2002. Full stop. Paragraph needless to state that in case an appeal is filed within a period of 2 weeks.
I already filed, my lord.
Filed already. Seeks leave of this court to withdraw the writ petition. Is dismissed as withdrawn with liberty to the petitioner to pursue the remedy of appeal.
Obliged.
Most standing counsel for State Bank for a long time.
Yes.
Obliged.
Thank you. Of course. Yes,
it's not the case.
Bank
will not pay.
130.
133 to 138 the balance.
Yes.
This matter came with the respondent.
Stobaka
batch mila.
Yes, batch.
This Alamruko granted stay mila. You have the SLP pending before the Supreme Court. Now your SLP is both closed.
Order has been upheld. What? Which order SLP was pending, Mr.
Initially, earlier notification, tobacco notification was challenged before this armed court. Before this armed court dismissed the writ petition. Challenge the writ petition. They filed SLP before the Supreme Court. Initially, the stay was granted the Supreme Court. Now it is closed.
Closed on the, you should.
It was 1 year period is closed.
Mr. On the ground that it has become infructuous. Don't say closed. I mean, this is again a misleading sort of a submission saying that adjudicated on merits. So be fair to the court, dismissed on the ground that it has been rendered infructuous.
Yes, we involve the 1 year period is closed.
So nothing turns it. Fresh notification leave is also granted.
They challenge the fresh notification. Earlier, the Supreme Court dismissed the
This is 2023.
Yes, my lord.
Now the challenge is earlier that matter is 2022.
2022, my lord.
That is over.
It is over.
Lordships,
This
my
Honorable Court, same set of document dismiss the.
Correct, Mr.
Lordships, my small submission, your lordships. I am for your petition number, item number 134 to 138, your lordships.
Fine.
Lordships, whereas in my petition, your lordships, 382
No,
of
no.
2023.
Are you aware about this order?
That was not served by us, your lordships. Earlier, your lordships, the lordships has directed them to file counter and stay vacate petition, your lordships, but they did not file.
In WP 638, it was extracted in the hard copy, in the interim hard copy.
My small submission, your lordships.
Relying on previous year. So they are relying on the order passed by the division bench in relation to previous year.
Lordships,
So-
that is, I to admit, your lordships, but I have challenged of the notice.
No.
Your lordships.
Correct.
The changes circumstances.
Change.
Yes,
In addition to, because you will have to, Mr. You will have to convince us to take a different view than the one already taken by a division bench of this court.
Yes, your lordship. Page number 27 of my petition, your lordship.
All right, learn it. So we will hear sometime, learn it counsel for the petitioner, learn it additional comment advocate. Learn it addition. So against this order, SLP was dismissed.
SLP was.
Learn it.
Small submission, your lordship. There was an interim stay was granted by this honorable justices, your lordships, but that was not extended, your lordship.
We don't want to extend it.
Lordships,
It is expired, cannot be revised.
no, your lordship. I challenge it of 2023, your lordship. The notification itself.
There is no interim.
Lordship, sir. My small submission, your lordship.
Of course, make big wise.
Page number 27 of my petition, your lordships. 6382 of 2020.
18/4/23 is the order. In WP 1046, there is no stay. Only issue notice.
23, there was an interim stay orders was done by these honorable justices, your lordships.
Whether you yourself said that it did not, this thing continue. If did not continue, file a fresh
Your
application.
lordships, I file of this petition only, your lordship.
Instead of focusing on interim order, focus on main thing, what we have dictated in the order. You have to meet the reasonings assigned by the division bench of this court, which binds us. You have to tell us why we should take a different view in your case. That job is not that simple as of saying that interim order which has expired should be continued, right?
Lordships, in my petition.
We are giving you opportunity.
1 second, your lordship.
Mr. We will not. You want us to reject it? You want us to reject that prayer? Please.
No, your lordship. No, your lordship. But
We
I
will-
request, my submission is that
Submission.
27 page number of my writ petition, your lordship.
No, which writ petition?
Police are registering the cases against the tobacco. Even lordships, when there is a specific direction of food safety of central government, your lordships.
Get ready in 2 weeks. We have said get ready in 2 weeks and tell us how you want to distinguish your case from the
This
judgment
one.
rendered by this court.
Me not to
No, you have
just requesting your lordship. So
nothing.
that is my humble submission because there was a specific direction by.
No, you want to argue on Saturday? 19/8 we are coming to the court.
Any day.
On Saturday.
Friday maybe also adjourn your lordships. I am ready for arguments, your lordships.
Friday.
This Friday.
Will we speak for the whole day? Friday. Saturday full day.
We will be sitting for the weather, but we will be sitting, we will be sitting for. No.
Friday.
This Friday, much obliged.
Yes. Your job is not that easy, Mister.
Lordships.
You know, right?
I admit your lordship.
Yes. That's why.
Much obliged, your lordship. This Friday in the motion list, your lordship, because my senior counsel is coming from Delhi, your lordships.
They don't threaten us by coming from Delhi. Let him come from London. We are not afraid of councils coming from Delhi. Don't, I mean, especially I am very sensitive about location. You want to threaten us by saying coming from Delhi. Let him come.
That is
And
not
we will give a copy of the order so that he can, he can take it away to Delhi where he practices, right? We will supply him a copy that very day. Don't tell us the location of councils. For us, a council is a council.
My lord, one submission, my lord, please. One submission, please. Item number 64, the Honorable Lordship has directed to wait, my lord.
Wait 1 minute. You are Mr. Ramnath Reddy.
For the respondent municipality.
1 minute, 1 minute. 1 minute.
Yes.
1 minute. We'll take it up before rising. Don't worry. Just it cropped up in me. That's the idea where we need to. Yes, 139. Yes, Mr.
My lord, sir, counter, my lords, 139, 140, my lords. I request 3 weeks time because I just received parawise remarks in this matter.
Your respondent number?
35, respond number 3 and 4.
Learned counsel for respondent 3 and 4. Praise fund is granted for 4 weeks time to enable him to file counter.
Already 3 months are given, my lord. 3 months are elapsed, my lord.
Yes.
2 weeks.
File it, Mr.
Yes, ma'am.
3 weeks. Finally, correct. Finally, 3 weeks.
Deep level.
Correct. Yes. 41.
My lord, I'm appearing for first and second respondents, my lord.
Direct.
Learned counsel for respondent number 4 weeks. Learned counsel 5723 is the order, right? What is it? No, who is for the petitioner? He has to pay the installments, right?
Within 1 week's period, they have to.
No, pass over.
Not paid.
Not paid, Mr. This petitioner is, don't seek an adjournment on his behalf. Yes. 143.
One submission, my lordship. Item number 77.
Don't do like this.
You're not, this
Huh?
is continuing. You can't interrupt like this. Yes.
What?
I apologize.
You have written in hand like young child. Huh?
I
Don't
apologize.
have a piece of paper?
This is coming for counter.
Counter 143.
Yes, my lord.
Laureate Council
this-
correspondent number
2, my lord.
2, 4 weeks. You file, Mr. Counter.
Yes.
Yes, ma'am. 144.
For illegal.
Oh,
This court directed him to approach the couple who filed and they rejected.
password. Nobody's there?
Who is the council 144?
One.
I'm waiting for the respondent 155.
Yes, what do you say?
But this court directed them to approach for human rights violation, illegal detention admitted,
Password.
inquiry ordered against the officer. What more is required? Damn.
You have to file counter. Let counter, if any, on behalf of respondents be filed within 4 weeks list thereafter. Yes.
Item number 145, I am for the petitioner, my lord. Today I have filed the proof of service, my lord.
Huh?
For USR number 7781.
This is not your, this thing. Learned counsel for the petitioner without consent. Learned counsel for the petitioner submits that the award dated 10/7/21.
This one.
10/7/21 was passed in the Lok Adalat without his consent by impersonation. Correct?
Yes.
He further submits that he shall file a proof of service during the course of the day.
Already filed today. Today we have filed. Today in the morning we have filed.
He shall file the proof of, that's what we have said during the course of the day. What else do you want?
Let's have instructions to appear on behalf of respondent number 2, your lord.
You should have responded by now. Counsel for respondent number 2, praise for is granted.
First,
how much time?
2 weeks time.
2-3 weeks time to enable him to file counter. Yes. Next.
Same 143.
My lord, sir, in this matter, though.
Go along with the item 143.
3, yes.
143 and
1 and 2 pray for and are granted. Counsel for 1 and 2. How much time we have granted in?
In that 4 weeks, your lordship, sir.
4 weeks. List along with item 143.
Yes. 147 also said.
147 safe. 147 safe.
Well, I just wanted to bring it to your lordship's notice, though if by virtue of interim order, my lord, so some, all the petitioners were permitted to write examination on 22nd or 23. Some of the petitioners have were absent on that day.
did not appear.
They have
So
not-
you file an application for deletion of their name. Right?
Yes.
So learned counsel for you, which case they didn't appear?
In 147 and 146.
Acha, 146 and 147, learned counsel for respondent 1 and 2 submits that some of the petitioners, even though petitioners were granted the liberty to appear in the examination in pursuance of interim orders,
Dated
interim order dated
19/7.
19/7/2023. However, some of the petitioners have not appeared in the aforesaid examination
22nd and 23rd
held on 22nd and 23rd of July 23. Learned counsel for respondent number 1 and 2 praise for
filing an appeal.
however, the learned praise for adjournment to enable him to mention the names of aforesaid candidates on affidavit.
Yes.
As well as to file a counter within 4 weeks.
Deeply.
All right. Yes.
Lordship's matter pertains to the.
Fine. See, he is not permitting you to argue. He is conceding that genuine public interest, Mr. Prabhakar is appearing. All right, learned special. Understand, Mr.
But already 15 months over.
We have read it, right? We have read it to find out what is this allotment, PIL allotment of a government land for office of a, to which he, like government he represents, right?
State and for 100 rupees, they sell an acre for 100 crores. Same area land, you give it for 100 rupees and you sell it for 100 crores.
100 crores
Huh?
per acre.
Per acre.
Fifth respondent has already been filed the Bakalatnama, my lord, but he didn't file the counter.
Let him not file. Consequences will ensue, right? Fine. Fine, whatever. We can't compel them to file counter. Who you appear for, Mr. Harin Prasad?
For the state.
Learn it. Senior.
1 to 4.
1 to 4. How much time?
1 to 3 weeks. 3 weeks.
Final judgment.
Let him. Land will not run away, right?
My lord, if they would be constructing their offices, that's the problem.
You will get 100 crores each. Why are you worried, Prabhakar? Huh? That is the benchmark you have within 1 week.
Land with the building probably will be allotted to you. The issue in this public interest litigation, in this public interest litigation, right, 148(1), in this public interest litigation, the petitioner has assailed the validity of impugned GOMS number 47. Same.
Next matter also same.
Same after 3 weeks.
Bless.
Yes.
I beg to represent. I require 4 weeks time to file a reply, my lords, because
you are appearing for whom?
I'm appearing for the petitioner.
Oh, learned senior counsel for petitioner press friends granted 4 weeks time to file replies to rejoinder to the counter filed on behalf of respondents.
Obliged.
This thereof. Yes. Affidavit filed.
I'm in item 152. May I make one humble submission? There's a larger batch, Lordship, WP number 9836 of
Please
2000.
file an application, then we will find that larger bench and this bench is different.
With great respect, it's a, what I meant is a batch
What
matter.
we are saying is that please file an application linking both these petitions by assigning reasons.
Excellent.
Very often we have found that oral submissions, then the other counsel in that larger bunch will say that my case is different, who has got it linked.
Lordship, in fact, in
He
the
will not know that at 140 you have made a prayer to the court for linking.
my special GP might in Lordship. I meant there's a
Common ground, then fine. If you joint submission, then fine. But you are appearing in all those cases.
So for a senior counsel case, Murthy sir is leading that matter, Lordship.
No, you are appearing in all the cases other which then file an application for linking, Mr. This is in any case a PIL.
Yes, sir.
Fine. Nothing. Protect the water bodies. We are already doing it in a batch of writ petitions around 20.
I bow down.
There's nothing to senior counsel shouldn't appear in public interest litigation until unless appointed by amicus. As amicus. This is what we think. Young people like you should prepare it and argue. There's nothing leading. What, Mr. Affidavit, have you filed?
I have filed, Milord, out of
16/8/2022.
Milord, in bill number 80 of 2022, Milord, I have filed my counter.
87.
In the other matter, Milord, I have to file. In 87 also I have filed.
87 filed.
I have filed.
Learned. You are appearing for whom?
Milord, I am appearing for the respondent number 2, Milord, in bill number 80.
Learned counsel for respondent number is obviously 87. Learned counsel for respondent number 2 submits that in compliance of the order dated 16/8/2022, he has filed an affidavit on.
Milord, on
There is no affidavit on
September.
6th day of September
2022.
6/9/2022.
Yes, Milord.
Oh,
yes.
So it is on record. My copy not there. Yes. What do you want to do in view of affidavit? Nothing.
Your Lordship, I'll take steps to file a reply, Lordship.
Learned counsel for petitioner press fund is granted. How much time?
Lordship may say 3 weeks.
3 weeks time to enable him to file reply stroke rejoinder. What about 152, Mr.?
But in that also, but I have filed it only on 7th September I filed. Instead of 622.
Same order? Fine, you file reply. And file an application for linking by assigning reason, right?
Obligor.
So that everybody has noticed. Yes.
So also, my lord, I request 3 weeks time. File counter in this one.
Counter, what is it, Mr.?
Subsequent to this, there are changes, but subsequent proceedings have also been issued. I'll file.
Ah.
1 to 4.
In the subject matter of this public interest litigation pertains to allocating prime government land to the extent of 11 acres in Kokapet village. Where, Mr.? Kokapet village of Rangaragi district. Learned, senior learned so and so special whatever. Press warrant is granted 3 weeks time to enable him to file counter. Yes, next. What is this? Learned, you appear for whom, Mr.? You know, for whom? Learned is special. Respondents pray for and granted 3 weeks time to enable him to file counter.
The tribal area elections.
Yes, what is some, who was saying something about Mr. Reddy? No. Yes. Item
number
64.
64. Where is the council gone? 64. We had told him that we'll pass an order like that. 1 minute. So what the grievance is about the illegal construction, he has made a complaint to you. You look into it, Mr. Your inaction, people come here.
Just a minute.
You want to contest by filing a counter.
He made a complaint against the 10th respondent, which is at page number 85. Insofar as other representations are concerned, not to me, to the other officials.
Whatever is he has learned council has agreed. Obviously, you cannot decide the representation not made to you, right?
Yes, Malad.
So we will direct that whatever representation has been made to you. What is it dated?
8/6/2023.
23. You decide this representation.
Against 10th respondent.
All right. Just a minute. You decide this. We are passing in innocuous order.
We already decided. We issued notice on 9/6/2023.
Mark the presence. Learned counsel for respondent number. You are
7th respondent.
Learned counsel for
respondent number 7.
Manthani Municipal Committee or what? Committee.
Not municipal, municipality, that's all.
Municipality.
Yes.
Municipal council. Municipal council submits that the petitioner has made a representation addressed to the municipal council dated 8/6/2023 against respondent number 10 only. It is further submitted that none of the representations annexed with the petition have been submitted to municipal council so and so. It is further submitted that the aforesaid representation has been decided by municipal council on
9/6/2023. We issued a notice.
So what is it pending decided? What happened?
We passed orders to remove the illegal.
It is further submitted that in pursuance of the aforesaid representation dated 8/6/2023, the municipal council has passed an order on
23/6/2023.
23/6/2023 directing respondent number 10 to remove the illegal encroachment.
The officials
to remove encroachment, not illegal. It's a
the officials visited the house of the unofficial respondents on 23/6/2023 to remove the structures. The unofficial respondent number 10 and other family members poured kerosene and they tried to commit suicide. Therefore,
and I filed a OS against you seeking injection, so therefore
also
can't take any action.
FIR is issued, Malad.
Delete then. then you take notice if you want to
Yes,
contest.
Malad.
Huh?
Notice also issue, Malad, we filed a complaint, the Malad,
No,
FIR
you
was
are
also-
telling a story, Mr. What happened to his this thing?
They are trying,
Mr. Please understand.
Malad, they are trying to.
Please understand, the only limited query grievance of the petitioner was, I have submitted representation, the municipality has not taken action. You are telling us action has been taken. What has happened?
Malad, in view of Malad.
The order of removal of encroachment has been passed, correct?
Yes, Malad.
Order of removal has been, encroachment has been passed on what date? However, removal of, however, the encroachment has not been removed as
They try to
respondent
submit
number 10
suicide,
and
family members.
family members have issued a threat of self-immolation.
Yes, Malad.
But it can't be like this.
Malad, we filed complaint, Malad, we are pursuing, Malad, we will definitely.
See, further learned counsel for the municipality further submits that the municipality passwords at 2:30 now. Yes, yes, Mr.
Request.
Huh?
Yeah, sure. I had made a mention for listing of two recoveries. They were directed to Mr. on 17. Then the registry we found that the date is erroneously mentioned as 17/9. In fact, it was directed to Mr. on 10/8. 10/8 I should have had some inconvenience. So it was directed to Mr. on 17/8. And we found in the registry that the slip.
No. Who has mentioned the date? A typing mistake in our order.
Not the order, but the slip, maybe by the court officer. 17/8 was the date given.
Written it as 17/9. Which year matter, Mr. Prabhakar?
Because this is for considered interlocutory applications where report is required to be filed. This is the discipline proceedings against the IAS officer. 10/8 your lordships have directed. 10/8 I said I am not attending the court.
Better we'll see date. It is 18.
Today, my colleague went to the.
All right, so 18th August. Give 18th August.
Schedule officer can be. I
What?
one of the petition on 14/8/2023. 14/8.
Hey, where were you there? Acha, no, not there in the morning, right?
Sorry, but I informed that 1:30 you have to make a video.
All right. Yes. No mention day. Yes.
Permitted movie like motion. Tomorrow the DB scheduled in the. I also find same is numbered as supposed to come today. It should be done. Not at this day.
It will come tomorrow morning. If DPC,
DB scheduled is there.
DPC held also, what will happen, Mr. Satnarayana? You are telling.
Once the promotions are effected.
No, DPC, the day, same day, they won't pass orders, no, DPC. You know, I know what happens.
I know.
Then
I have to be placed before the DPC, but I never have to be included. Permitted movie lunch box, maybe matter of 2 minutes.
No.
it will come to.
Tomorrow.
Tomorrow, let the order them, but some urgency, the otherwise of them.
We have considered and said, it's not that your house is being demolished at 3:30. Not like that. Supposing if the bulldozers would have stood outside your house, this thing and we would have granted stay. We have understood DPC and your name, and it is likely to be convened tomorrow. It will be convened. Tell him.
Matter is of the third roster. Correct? DB3.
Then why are you making a mention before us? DB3. It will come tomorrow.
Lordship, also matter. Serial number 74.
Sir, what's the time? How can you be so unreasonable, right? Ah.
Your lordships. The petitioner.
Notice, you are challenging the notice
Yes, my lords.
of appointment of arbitrators, correct?
Yes, my lords.
So all objections can be filed by you under section 60. Everything including jurisdiction and everything. Why we should entertain a writ petition?
The cause of arbitration is not there.
Section 60. Rule on its own jurisdiction, including ruling on any objection, existent validity of arbitration agreement for that purpose. Everything.
When there is no cause of arbitration, they cannot proceed further.
There is no
cause of arbitration.
Cause of arbitrator.
Just like cause of action. Final payment was made in the year 2004.
Clause of arbitration is there or not?
No cause of arbitration.
That also you can say.
I rely on the judgment of the Honorable Supreme Court, where it was held that when there is no cause of arbitration.
No. So, like, you mean to say that Supreme Court says that as soon as notice of arbitral proceeding is issued, the court should entertain a writ petition and grant stay,
No.
right? Where is that judgment?
When the matter is hopelessly barred by limitation.
That you can, it's only a notice. You can rule, you can raise all objections. Show us that you can't raise. If it was barred by limitation, nonetheless arbitral tribunal has been constituted. We are dealing with, we can't set aside you are seeking quashment of this thing. He's saying, you are arguing on facts that I have paid this thing loan and this thing that we can't adjudicate under Article 226. What is the loan taken when it was?
There is no cause of action for the claim. No cause of action for the arbitration.
We have understood. Understood.
Narasimha, forget it. Your agreement.
My lords,
1 second. Your agreement under which you have obtained credit card has not been filed. That will have the arbitration clause.
That is not supplied to me. Every bank, even
we will issue notice and make a direction to them to this thing supply the arbitration clause to you, right? This is what you expect.
Not like
not
like that.
Then you have to.
Your lordship may see the para number 7.
You can raise all of this. No, the agreement actually, this is a credit card payment. The agreement under which card is taken will have an arbitration clause. So therefore, it is not correct to say he doesn't have, there is no arbitration clause. The rest of the issues he can
read
under section 16.
No. Where is this thing agreement which contains an arbitration clause? The agreement produced.
That was not supplied to me.
Then you are.
And if your lordship.
So then you, if you are not filing it, then
your lordship, when it is not supplied to me, how I can file?
No, challenge any order passed by the government, say it is not supplied, so it is the duty of the court to find out.
No, my lords. No. I am sorry. My lords may see the para number 7.
No. Where is the agreement?
Agreement is with the SBI cards. The respondent number.
You produce it to.
You have not even asked them to give you a copy of the agreement because you are conscious when you have obtained a credit card.
No, my lord. That was not supplied. I have mentioned in the in my reply to the arbitrators. I have mentioned the same. That copy of agreement was not given to me.
No, don't tell us that you can't get that agreement.
That I will issue a notice for production of that.
It's your petition, mister. We are not challenging. We are not asked to appear before arbitrator, right? So we'll dismiss your petition saying that he has not filed. So therefore, it is not possible to ascertain whether or not the arbitration agreement. Therefore, challenge in the petition on the ground no arbitration clause fails, and petition is dismissed.
I will request the arbitration.
Immediately we use the word dismissal, then immediately you respond. Otherwise, we have been telling you, brother has been telling you, please produce the agreement. Where is it? You don't get it.
That I will issue notice and.
No. Till now you are saying it is not supplied to me.
Not supplied.
The moment we said that dismissal, it immediately you got it that I will file.
Even I will issue notice and then only.
No, nothing. Nothing you.
Your lordship may see
All
this page,
this.
paragraph 7.
Nothing.
The last 4 lines, my lord.
Yes, yes.
So merely to only to see whether there exists a plaza.
All right. Anything else?
That the last 4
lines. Para 7, you read.
Yes, my lord. The opposite party, it was according to that in the case, since the petitioner slept over his rights for more than 10 years, by his conduct, he allowed the arbitration to be barred by limitation, and the court would be justified in.
What was challenged before Supreme Court in this case?
Court would be justified in.
No. What was challenged? We asked you. In this petition, of which you read for last 4 lines, what was challenged? A notice issued by the arbitrator was challenged.
Yes, my lord.
No, Mr. You have to be fair to the court. This was an order under Section 8 of the Arbitration Conciliation Act. If we ask you, that doesn't mean that we won't be able to find out. And you tell us why we should not call you up for making incorrect factual submissions. We said whether notice issued by arbitrators challenged in judgment of Supreme Court, you said yes. This is not so. Read para 2 facts. You owe a duty all the time, Mr. Counsel. You are an officer of the court. You do owe a duty to be fair to the facts at least on the facts. Don't, Mr. Nothing. Yes. Third, on the question of admission in this writ petition, the petitioner has assailed the validity of the notice dated 8. See, madam, there are 2 cases here. One is Station Council is found, and where there is a listing. We can do something. Those 2 cases are really remaining cases you call.
So let's see. 2 matters are there. One is check code is not the cutting. I mean, the cutting arguments with man.
And one is 1 minute.
Yeah.
That is all at the end of the cases, because any other password we should finish.
First
The
other
one
passwords
is
are finished and then call for.
Yes, so that those are to be heard. Yes.
Lordship.
Yes, Mr.
Obviate the necessity of one more trial. Petitioners have filed WP.
No, we were wondering that the order seems to be in your favor. Why have you challenged?
Lordship, Honorable, single judge's order is against principles of natural justice.
Naturalist, you were not heard.
Heard, but not considered. Not considered the prayer.
Not considered. Supreme Court says go and file review. If arguments addressed by you have not been considered, the remedy is 82 Supreme Court 149, 130 or 149 A.R. Antule's case. Remedy is to file review. We cannot say before division bench I argued because none of us were there. The file review. Seemingly the order we went through the order, it appears to be in your favor. We wondered why are you challenging it? I asked my brother also in the first round when we were not there. I asked, I have doubt how petitioners are challenging. Your petition for, do you think that market value of the land can be decided in Article 226 and court gives a finding that this is the market value, therefore so much of compensation shall be paid to you.
Okay, keeping in view principle of restitution, our prayer is
that restitution is 28A Land Acquisition Act. Everything is open to you to argue.
There's a precedent basing on that.
The restitution also he can argue, and the proceedings have been directed to be concluded within 6 months. 6 months.
Claim within 3 weeks and thereafter 6 months.
Have you made a claim? Not yet.
So, Lodge.
Have you made a claim in pursuance of the liberty granted to you?
Not sir.
Then
The time is over.
time is over. Be happy. Travel northwards. What? We are affirming the order. Allow, if you want a copy today also.
Lordship,
Please
consider the
17
case law. We adjust.
No, please come to page 17, para 10 and read what is the liberty that is granted by the learned single judge.
Lodge, one second.
You are arguing
the writ petition is accordingly allowed. The respondent number 2 is directed to refer the matter to the competent civil court in terms of subsection 3 of section.
So what first line
in
writ
para 10.
petition is allowed.
Allowed.
Can you file a writ appeal when the writ petition is allowed? The writ petition is allowed. Can you file a writ appeal against that?
My grievance is that
That learned single judge should have determined the market value. Got it. That's what you want, right? The learned single judge should have determined the market value of the land and should have awarded compensation instead of relegating you to the remedy of 28A. Correct?
Millard, on par with Apex Court.
Yes, fine.
Have you made a reference within the time granted by the learned single judge, madam? It is referred. So 3 weeks, within 3 weeks from the date of receipt of the copy of the order, reference has been made under 28A. So we will record it that it has been made. Earlier, it was 4,000. Connected matters, it was decided as 25,000. So he wants parity. The learned single judge gave a direction to refer under 28A. Have you referred within 3 weeks? If that is so, we will record and direct the court below to dispose it of. Then you are at default.
Fail to refer.
Read para 10 of the order, madam. You have to make a reference. You make a statement that now within at least a week or two, outer limit of 2 weeks, you will make a reference.
Hello.
This intra-court appeal has been filed against an order dated so and so, order dated File.
Illegal encroachment, not flag.
You call. Yes. All 77, not end of the list. None for the petitioner, even when the matter is called in second round.
I may be permitted to withdraw the same, my lordship.
So and so learned counsel for the petitioner. Learned counsel for the petitioner seeks leave of this court to withdraw the same, as petitioner has already filed another PIL, namely WP PIL SR number 767/2023 with regard to subject matter of the instant public interest litigation. In view of aforesaid submission, the writ petition is dismissed as withdrawn.
Obliged.
$79 GP for assignment Kiran Reddy. This is
80 is
many
passed.
matters are there.
How many?
98. So 98 we call first, then these two later. 79, 80 later.
79, 80 that those matter.
79, 80 we'll call later. Just wait for the other small passovers we can complete.
No, 79, I don't think condone delay. All 79 matter. Probably 79 condone delay. No, 79 is your matter, Mr.
Pardon me, we asked for
Passover to condone delay.
Condone delay. What you want to argue? Condone delay?
Delay of 1543 days. 1543 days.
So will you explain by filing a better affidavit?
In 5 years.
Let's paragraph
1543.
1543 days, let's.
Will you file a better affidavit, or you want us to go through? You know better. Senior counsel has come to oppose the condonation delay. That means you should be on alert mode. He is right. So file. You want to file, you don't want to file.
I'll file.
How much time?
2 weeks.
Present 79, learn it. 3 weeks.
2 weeks, minutes.
Learn it, see, whatever. Special GP. Praise warrant is granted 2 weeks time to enable him to file a better affidavit in support of condone delay petition, namely IA 1 of 22. List thereof.
Let's IA 2 is concerned, it's a delay in representation.
That we can find. Delay in
138.
Delay IA 2 of 22, delay in representation. For reasons assigned, condone delays, condone IAs.
Already controlled.
Already? See, madam. You see that. See, if it is condoned, then don't this thing. If it's not condoned, then pass. All right.
Publish.
If it's not already condoned, you file a better affidavit. So 80 is pass over, and then one other case, 98. These are the two cases. Call 142.
It is not condoned.
Not condoned.
Not condoned.
Your matter is Mr.
No, I checked up the docket. It is not there.
It's condoned, right? Yes. File a better affidavit 1-5. How many days? Yes.
Order is there in the proceeding to file a better.
Madam, which 142? Which case is your one, Mr. 90? 98. All right. So we take up only one case left. 142. Call 142. None for the petitioner. Even when the matter is called in second round, it appears that the petitioner is not interested in prosecuting the writ petition. Accordingly, the same is dismissed for want of prosecution. Interim order, if any, stands vacated. No, not 80, 80 and 98.
79.
80. It will go according to CBA. Yes. Outstation. Yes, 80. After this, your matter, Mr. Huh? Yes.
A lighter note.
Yes.
Well, I believe I may first have to make an endeavor to persuade your lordship that some matters which take more than 10 minutes still may be good matters.
Of course. No, Mr. I mean, this is only we say with the council to bring in more clarity in their this thing when they address.
Once we start, because your lordships have been handling so many matters, so it is always better to start on a lighter note. That's why, with your lordship's permission, I took the.
Yes, please.
The appeal arises from dismissal of a batch of petitions, but however, I am concerned only with one writ petition, my lord, which is 30855 of 2016. Writ petition 30855 of 2016, which stands dismissed by the order under appeal before your lordships, my lord, dated 28/4/2023. This, my lord, writ petition or the writ appeal arising therefrom concerns about
the petitioners therein.
Who are the petitioners? Who are the appellants? My lord, concerns 53 acres of land. But the writ petition was in a very narrow compass, my lord. And if I may, my lord, take the liberty of inviting your lordship's attention to page 87 as to what was the prayer and against whom the writ was filed, or against what action, my lord. Your lordships kindly oblige me and have page 87. The prayer is set out at page 88. My lord, it was filed initially against 5 respondents. The first respondent whose action principally was challenged was the Telangana State Industrial Infrastructure Corporation Limited. It was apprehended, my lord, that the state authorities were extending their help to the respondent number 1. That's how they were joined. The prayer is set out at page 88, my lord, and if I may kindly place the prayer. For the reasons stated in the accompanying affidavit, it is hereby prayed that the Honorable Court may be pleased to issue a direction, order or writ, or more particularly one in the nature of a writ of mandamus, declaring the action of the first respondent in attempting to enter into land of the petitioners to the extent of 53 acres 00 gunthas situated in survey number 83/2 of Raidur Makatha, so-and-so Mandal, Rangareddy district, and attempting to demolish the fencing without causing any notice or without any right, authority, in spite of the orders of this Honorable Court, as illegal, void, malicious, and direct the first respondent not to cause any demolish the structures by the petitioners and not to remove the fencing, blue sheets in the interest of justice. One of the basis was that the present appellant petitioners, my lord, had 7 registered sale deeds. There was an attempt, my lord, by the Honorable Lokayu on a complaint made by.
What are the dates of these sale deeds?
Well, I have presented the list of dates, my lord. Since the record is quite bulky, I took the liberty on the earlier.
Yes, please.
List of
dates.
I have a separate, same copy, my lord. My lord Justice T. Vinod Kumar, who was presiding over the bench, will remember I had given the list of dates, my lord. When notice was issued. It's the same copy. I served it to list.
List of dates.
Yes.
Page 29 of something handwritten thing. Right? 29 you are referring to.
No. I'm just indicating, my lord. Firstly, I read out 87, 88, my lord. Just kindly give me a moment. It is my list of dates.
Short list.
This is titled a short list of dates.
Yes, but that's inappropriate, my lord. I admit, my lord. It's completely inappropriate.
That only reminds me, brevity in arguments running into multiple volumes. That is the book.
This was only to compile all facts and give the relevant page numbers, Malad. And extract, so every time I don't have to trouble your lordships.
For the moment, we will ignore this short thing and.
I'm grateful, Malad. I'm grateful, Malad.
Malad. Yes.
So, Malad, the case was, and I'll take your lordship, Malad, immediately, that, Malad, there were two subsisting interim orders. One, rendered in a writ petition of 2011, which is still pending, and the interim order subsisting.
Just, if you can refer to this date so that we can.
Yes, Malad. Oh, may I start, Malad, very briefly narrating from the beginning. Malad, there were 525 acres of land belonging to 11 pattedars, who are, Malad, the holders or the declarants, as we say, Malad, under the Agricultural Land Reforms Act, which came into the state into operation in 1973. But those lands were subjected to land reform ceilings. And, Malad, I would beg to say that it's an admitted position, and I'll make good that submission on basis of the government's affidavit, that out of those 525 acres of land, it was held that 470 and some guntas was held as retainable land under the Agricultural Land Ceiling Act. What was declared, Malad, as excess was 99 acres, Malad, and 07 guntas of land.
Yes.
Malad, it's also an admitted fact that possession of this land, 99 acres and 07 lands, which includes the 53 acres of land with which we are concerned, was taken by the government under the Agricultural Land Ceiling Act. Then comes, Malad, the division bench decision of this honorable court in the year 1977, which in my, Malad, humble submission took the view that when you have agricultural lands which were subjected to the Agricultural Land Ceiling Act, and if they are situated within the urban agglomeration of an urban area to which provisions of the Urban Land Ceiling Act apply, then, Malad, those Agricultural Land Ceiling Act does not apply. Well, these dates are important. 17 to 1976 is the date on which the Urban Land Ceiling and Regulation Act, while it was in force, Malad, came into operation. Malad, your lordship will recall, Malad, various states had passed resolutions under clause 1 of Article 252, and therefore the Malad, Parliament had to enact the law. So, Malad, what happened was these lands were there. The declarants or the holders or the owners, Malad, were required to file a form under section 6 subsection 1 of the ULC Act. I'll call that ULC Act and Agricultural Act for the purpose of. Such forms were filed. What was declared as excess was the retainable land under the Agricultural Land Ceiling Act, which is 470 acres and some odd guntas. Well, another admitted fact is this order declaring, which was followed by, lordships are aware that there is a draft statement under subsection 1 of section 8, followed by a final statement. the lands were subjected to proceedings under the ULC Act. In the list of dates, my lord, which I handed over.
6/12/79, correct?
It will be page 6, yes, my lord. 6/12, I'm obliged. As stated above, as lands were situated within the urban agglomeration of city of Hyderabad, they were subjected to proceedings for determination of excess urban vacant land by way of filing a declaration under section 6(1) of the ULC Act. Various pattedas, landowners of the land, filed these forms. By an order dated 6/12/79 in exercise of powers under section 8(4), read with section 9 of the ULC Act, the special officer and competent authority ULC Hyderabad issued separate final statements of even
So, this thing, the scope of this writ petition, as we understand, is very limited. You claim to be in possession of the land in question, and your case is that you cannot be dispossessed without
without following due process of
law,
which includes notice.
If respondent number 1 is claiming title, whosoever, he has to take recourse to whatever, if you want to take, or anybody, that question of title cannot be gone into this, the Supreme Court position. And if any person in possession cannot be dispossessed except in accordance with law 68 Supreme Court 620.
Lordship, please. I couldn't have summarized it better, my lord.
So why have you lost out on single judge? What has been
great respect to the learned single judge and not humility, all humility at my command. The scope of the writ petition got extended. How, my lord, I tell your lordship in a moment. First came the original landowners who had never challenged my sale deeds and set up a case of, my lord, adverse title, which the learned single judge goes into. The government, though,
yes.
And my lord, there was an interim order there were two earlier interim orders, one of 2011 in the writ petition, my lord, which your lordship will find the date. May I just bother your lordship with those two dates, my lord?
But where do we, one thing,
yes,
quickly you tell us two things, the date of your sale deed and when you were placed in position.
Yes, my lord. The date
and
of my
whether your name is reflected in revenue records, whatever.
The date of my sale deeds are, my lord, 6th day of June 2008. And my lord, there are 7 sale deeds.
Where do we get it?
Your lordship will be pleased to find it at page 136.
No, here this list.
In the list of dates.
So that we.
Yeah. Can that be?
Madam. 68 Supreme Court 620. AIR 68 Supreme Court 620. Get it.
Well, at seal number 34. So the mine and yours differ. I'm so sorry, Malad. You have the earlier one.
Has to be earlier.
No, what I had given. Sorry, I'll just. Well, the list that I had prepared, I had split up into 2 parts. There's little confusion there, but your lordship will find the document at page 136.
Oh, but could you tell us the date?
Yes, 6th of June. Yes, my lord. Running page 30, there is, my lord, another list of dates which says serial number 1. Yes, my lord.
Yes. So this is not the difference being that this is not short list of dates. So never accurate.
While settling, I did realize I'd asked, my lord, my colleagues to take off, my lord.
All right.
As your lordships know, in these, my lord, days of cut and paste, sometimes, my lord, unintentionally, my lord, that word comes in. My lord, 6/6 to 15/12.
68 Supreme Court. 620. Yes.
These are the, my lord, my lord, my vendor is one Bhavna Cooperative Society. Now, my lord, the learned single judge goes into, and my lord, all payments by check, these are companies, my lord, my claim is that I am a bona fide purchaser for value without notice. I relied upon an agreement to sale, which was validated by, my lord, the registrar, by taking, my lord, the registration charges, as well as, my lord, the penalty envisaged under the Stamp and the Registration Act.
So, where is it that this sale deed contains a recital that you are handed over possession?
Yes.
Which revenue document apart from the sale deed that says that you are in possession?
Yes, my lord, there is one document, my lord, as my lord, your lordship will recall, that under the Agricultural Land Ceiling Act, 99 acres and 07 guntas were declared as surplus vacant land. My lord, I am consciously using the difference in language. Excess and surplus. Excess is under ULC and surplus is under the Agricultural Act, so that it can be identified. My lord, that land admittedly was taken possession of in view of a representation being made and the matter being taken by the power of attorney.
Be present, subject to what is argued by them.
Yes.
We have taken note of the scope of writ petition. So probably questions of title, we will ask them how it can be gone into a writ petition and a finding be recorded. If the sale deeds are executed in your favor, if anybody wants to challenge, he has to take recourse to the remedy, whatever. So we therefore at present we are only trying to ensure the time of SEC that there is a registered document of title in your favor, and you are placed in possession of that.
Correct.
That only shows that. So therefore your case is that you cannot be dispossessed except in accordance with
due
law.
Procedure established by law.
That's
And
the
my lord,
short.
secondly, when I came before the court, I was only, my lord, it was the Telangana state IIC which was taking that action.
No,
and
so that is
their
the-
order of allotment doesn't include this. My lord, I need to show that as well. My lord, if your lordships please oblige me and please have the order of allotment.
Page 88 is the scope. So we have now, you have told us that these are the sale deeds executed in your favor. Then you tell us when were you placed in possession?
At the time of execution of the sale.
Whether your possession is recorded in any of the revenue records anywhere.
Well, afterwards, yes, my lord.
Yeah.
But what the question is, my lord, I must tell your lordship that, my lord, these are the very lands of which once possession was taken in, my lord, November or December of 76, but re-delivered back under proper orders of proper authorities, and the date of it is 24th of April 1990. And your lordship will find that document at page number 254. No. It is 656 of the appeal memo. I'm so sorry.
One.
In your lordship's volume, it is, my lord, volume number 3. Please let me show that, my lord. There was an order of a tribunal. Pursuant to that order, $654. Would your lordships oblige me by having that page?
Which page?
654 of the paper book. It's in volume 3. Lord, how these proceedings arose was that after the judgment of...
What is it? This 654 is what is?
654, my lord, is a proceeding evidencing the fact that the government re-delivered back possession of 99 acres and 07 guntas.
Possession of
the land which was declared surplus under the Agricultural Land Ceiling Act, but which pursuant to the orders of the Land Tribunal dated 10/11/87 came to be re-delivered back.
What was the extent of land? 99 acres.
Yes, your lordship will find both in acre and cents and acre and guntas.
No, 99.17.
7 cents or 99 acres and 07 guntas. To Shri A. Ramaswamy, GPA of the Pattedas, Muhammad Abdul Aziz and Rukumuddin Ahmed are present. Therefore, land of so and so has been handed over. The order, my lord, pursuant to which this is at page 650. If your lordship would only want to see, or my lord, bear that date in mind, my lord. This was after one round which went to the appellate tribunal. It came back. It was remanded. 650 was. This order is nowhere challenged. Second, my lord.
650 is what order?
650 is the order of, my lord, the Honorable Land Revenue Tribunal, which held that, my lord, this land, in view of the decision of the division bench, requires to be given back to the original declarants or the patedars. I may add, my lord, at page 651, my lord, your lordship will. As per the clear directions of the Land Reforms Appellate Tribunal, 650 last line, in LRA number so and so dated 22/8/84, in respect of survey number 83 at measuring acres 99 and 7 cents of so and so is ordered for reverting back the possession to the declarant. The revenue divisional officer so and so division is requested to revert back possession of the above lands to the declarant and see that form number 11 is sent to this tribunal. Proceedings dictated. It is pursuant to this order that the
So
document.
that it should come in sequence first, that 10/11/1987, the order was passed by the land tribunal directing land to be handed over to the
Reverting back
landowner,
to the.
and then in pursuance of which 25/4/90, the possession of the
Possession
land was
was-
given to landowners.
Lordship, please. So
And this
is
these
only to show
10/11/87 not challenged.
no challenge. Now, my lord, why the state authority, namely the erstwhile Andhra Pradesh State Investment and Investment Corporation and now the Telangana state, well, they claim allotment of land.
There's no like pages here to make notes. All this is filled up. There is one next. Yes. Yes.
Well, their claim to a portion of land.
No, all this is like beyond the scope of the petition,
Correct,
right?
but this is only
It's all
prima facie
facts.
to show. I may show one more document only to buttress my submission that the Telangana state couldn't have done it even under a mistake of fact because their allotment order never included this land. That's my endeavor.
So this land was allotted to whom?
This land came back thereafter. No proceedings, my lord, under section 6, 81, 83,
Out of this 99 acre, how you were you purchased how much?
53 acres of land.
Out of 99.07 acres, right?
Yes, my lord.
Petitioners purchased
Under several sale deeds, my lord, which are placed on record.
sale deeds, land measuring how much?
53 acres. My lord.
53 acres.
Lordship.
Fine.
Well, what was allotted is at page 222. And that your lordship will be pleased to find in volume 1. Volume 1 of the appeal paper.
It was allotted to
at
whom?
page 222. This is the first GO 161 dated 13/2/2006.
In favor of whom?
In favor of Malot. Then APIIC, which is now Telangana State IIC.
Yes.
I may only invite your lordship's attention to the fact that it refers to 3 notifications under subsection 10.3, 10.5 and 10.6 of the ULC Act. In the preamble at page
10.3, 10.5 and
10.6.
Yes.
All of these, my lord, when your lordship will be pleased to go to, there are 3.
Yes.
Whereas in reference, the third read above, I hope I'm with your lordships.
Yes, yes.
Third read above notification under section 10(3) was published on 24/1/1981. Accordingly, land in survey number 83 measuring 424 acres and 13 guntas west with the government free from all encumbrances. Subsequently, a notice under section 10(5) was served on 3/3/81 directing declarants to deliver possession, but due to litigations, physical possession was not taken immediately. Finally, a notice under section 10(6) was issued on 19/7/93 and possession of surplus land of the extent of, please mark, 424 acres and 13 guntas was taken over on 20th July 1993 by conducting Panchnama and handed over to the Mandal Revenue Officer, MR or so-and-so, for safe custody. The land is in custody of MR. Then over the page, my lord, at page 223, para 7. Now, therefore, the government, in exercise of powers conferred by section 23 of the Urban Land Sealing and Regulation Act 1976, hereby allot the excess land of acre, please mark, my lord, 424.13 guntas in survey number 83 of so-and-so village of so-and-so district to Andhra Pradesh Industrial Infrastructure Corporation Limited for utilizing it to set up IT park project. At page 224, my lord, your lordship will find a sketch which de-alienates or demarcates the land allotted to them. Below that, my lord, is the 99 acres. So these are two separate parcels of land.
So your survey is 83
upon 2. Well, what happened was, my lord, I missed one link, my lord, lordship may pardon me, that when initially under the Land Reforms Agriculture Act, my lord, surplus land was declared, they nomenclated, my lord, notionally the entire land into two parts. 83 upon 1, which was held to be retainable under the Agricultural Land Sealing Act, and 83(2) consisted of land which was declared as surplus, which is 99.07, which in 1990 is handed over back to us. Now, my lord, their claim can be only this, plus there is an order dated 2/9/2008, which allots
2/9/2008.
My lord.
Where is that order?
Well, that, well, I couldn't find it on record, but there is reference to it in the order of the learned single judge and all documents. Lordship can take it, my lord, from me. That is another 46 acres. So the total, if I may, my lord, add up 424 and 46 comes to 470 acres.
420?
424.
And plus 76 acres.
And 46.
46 by 2/9/2008.
I'm obliged. 2/9/2008. So the total comes to, my lord, 470. And some odd acres.
And your case is that you are out of 470.
I am not in that.
Not in.
Now, my lord, this is, my lord, what is borne out by, if your lordships oblige me and see the first order which was rendered in 2016 when I came complaining to this honorable court. The learned advocate general, my lord.
Which case?
In this case, my lord, when my possession was threatened, I came to your lordships.
Yes, then what?
I had, my lord, two grounds to submit. A, that there are subsisting orders of 2011 and 2012 directing that my possession should not be disturbed. There is a status quo. And two.
Where is that status quo 11 and 12?
Yes, yes, my lord. One is an order of the division bench, and your lordship will be pleased to find it at 228. It will be in volume 1, my lords. Oh, I'm so sorry. What? No. Volume 1 is pages 1 to 232. That's what you say.
We have 228 in volume 1.
Lordship, please, my lord,
division bench.
Of my lord, the Chief Justice, Justice Lokur, as their lordships then were, my lord, sitting with my lord Justice Sanjay Kumar.
Yes.
Well, if your lordships, my lord, go over the page at 229 and peruse the order. We have seen the interim order dated 22/11/2011. It reads as follows. In the meantime, Lokayukta is directed not to pass any orders till hearing of this matter. While there is an interim injunction against the Lokayukta from proceeding further in the matter, there is no order restraining the state government or APIIC Limited from carrying on their duties. Under the circumstances, the state government or APIIC Limited are free to carry on their duties in respect of the subject land. Please mark the words, in accordance with law. Nothing survives in this application. It is disposed of. List on 12/9. This writ petition is still pending, my lord. This order subsists. Then please see, my lord.
What is this order? Saying that it is granting liberty to act in accordance with law.
With law. I did emphasize, my lord.
WP MP number 4612 of 2011.
Well, the writ petition number, if your lordship may oblige me, is 29547. In that, my lord, there is miscellaneous petition, which your lordship rightly notice is 4612.
Same, right? Not to interfere. And just send to file.
Which is first respondent.
So there is already an order.
Now, my lord, despite this,
So you say that their action is in contravention of this interim
yes, because
order.
it said in accordance with law, there had to be, my lord.
And they are threatening.
So,
you with disposition.
Yeah. So, my lord, notwithstanding this, they, my lord, tried doing it in 2012. So, I had to, my lord, rush to this court, way of writ petition 4466 of 2012. Your lordship will be pleased to find the relief and the orders at page 226, 227 of the same volume. Just one page earlier. Lordship will find, my lord, petition under Article 226 of the so and so with affidavit inter alia declaring the action of the first respondent, and your lordship will find, my lord, the first respondent is the district collector in directing second respondent so and so to demolish structures made by the petitioner in its own land survey number so and so with the help of the third respondent without due process of law is illegal and void, and direct respondents not to demolish the structures raised by the petitioner and its sister concerns, and not to remove the.
It only says that interim order to continue.
Yes, but my lord, over the page, my lord, what had happened was when I moved your lordships, my lord, on 17-2, your lordships were pleased to grant me an interim order and pleased to direct that I communicate to them by wire or telegram. 227.
This is the wire.
Okay.
This is addressed to the three, my lord.
72.
Well, lordships are aware. Sometimes we make the prayer, my lord, that at cost it may be. Well, those days we didn't have, my lord, email and all of those facilities. By order of the High Court dated 17/2/2012 in writ petition number 4466 of 2012, filed by the petitioner, that is Vishweshwara Infrastructure Limited Company, represented by its director so and so, while directing registry.
This petition is also pending?
This is pending and the interim orders are continuing. And this is so noted in the impugned judgment by the learned single judge.
So, yes, so then why your petition? So we have understood.
So between 2012 and
the sum and substance is that you have purchased the documents by a sale deed, registered sale deeds. Those sale deeds are not under challenge. It's your case that you are in possession. Then there are two interim orders subsisting in your favor. Despite that, and in one of the writ petitions, this respondent is your AP, what ICC?
AP, IIC, Ballot.
IIC is a party.
Reorganization, it is Telangana.
So it is a party. Despite in violation of these interim orders, again,
and the
you
last
are
thing
being threatened with disposition.
Yes. And there is no order or any Ballot competent jurisdiction saying or authorizing them to dispossess me.
Any forum disposition, right?
And
That's it.
Therefore, my
But why have you lost before the single judge?
The learned single judge went into the question of title, held something at the instance of the private respondents who would never challenge Malad the sale deed.
What has happened eventually? Please read that your sale deed has been declared to be void or
with respect to my sale deed, Malad, I have today even obtained certified copies that these sale deeds are not declared to be void. What was declared to be void are sale deeds of 91-92, which were in respect of that portion of land which fell within 470 acres, which was declared as excess under
like your predecessor, not exactly your predecessor, but somebody else.
Somebody else and completely different persons. There were, Malad. Motion 27. Everything else.
They should not have given. Oh.
Follow page 31, para 5.3.
Yes.
Page 31, para 5.3, the learned single judge with respect takes note of this interim order.
Para
5.3.
Yes.
Page 31. After quoting the order, my lord, 17.2, which I read out at page 227, the interim orders were extended from time to time and ultimately by order dated 16/4/2012, interim orders were continued until further orders. The orders are still in force. The respondent number 1 has knowledge of subsistence of the order.
Yes.
Now, my lord, then the learned single judge notes the contention of the district collector. I'm just giving the paragraph numbers. Paragraph 6.1. But if your lordship will oblige me and just have page 36, paragraph 6.4, even that counter say that what was declared excess under the ULC Act was 470.33 guntas. Your lordship will find that figure.
70.33.
I'm so sorry. Sixth line, para 6.4, page 36. Then, my lord, at page 38 is the government's own case. Last 3 lines of paragraph 6.5. Accordingly, under the cover of Panchanama dated 25/4/1990, possession to the extent of 99 acres and 17 cents was delivered to the declarants. It was delivered to the power of attorney holder. I've placed that document at 654. Now, my lord, there is a finding by a learned single judge in a different writ petition, which is writ petition number 8543 of 09, which judgment starts at page 829, where the finding is completely contrary to the findings recorded in this matter. And that matter is in appeal before your lordship, my lord, it is pending. Well, that was a matter which went into the question that when these lands were released and reverted back to the declarants under the Agricultural Land Sealing Act, it had to be subjected to the proceedings of the ULC Act because they were situated within the urban agglomeration. So that court went into the question as to whether in fact they were subjected to it. The court finds that these lands were never subjected. There is no declaration, no final statement under 8.4, no declaration under 10.1, 10.3 and 10.5.
What is the finding of learned single judge? Where?
Yes, the follow discussion starts at page number 73, para 27. The petitioners in all these writs have not filed reply to the counter affidavit filed by the respondents, nor have disputed the documents by the contesting respondent. From the above conspectures, the following undisputed events emerge. I told Malad the first 525, Malad, hurriedly I'll take your lordship's Malad. 525 was so and so. Declarations were filed by the Patedars, and what was declared as excess was Malad to the extent of 71.50 and 27.66, it adds up to 99.07. This is under the Agricultural Land Sealing Act. Possession was taken over for para 3. After the act came into force, my lord, And this is an important paragraph, my lord, in my humble submission. After the ULC Act came into force, so and so and 10 others filed their statements under section 6(1) in respect of the land of extent of 525 and 39 guntas on 16/9/76 and 27/7/1977. Section 8(4) orders and final statement under section 9 of the ULC Act were issued on 6/12/79 and 25/1/1980, declaring declarants as excess holders of, please mark, 470.33, which is 83/1. Then, my lord, over the page 75, paragraph 6. As per the order of the Land Reforms Tribunal, from District Judge Rangareddy, the Land Reforms Tribunal so and so re-delivered possession. So that is also, my lord, an admitted fact which I, my lord, placed before your lordships. Now, my lord, what the learned single judge holds is, my lord, that there was a dispute as regards, my lord, those sale deeds which were executed in respect of 470 acres, which was declared as excess under the ULC Act. That is at page 76. The government allotted 424.13 guntas to APIIC, now TSHIC, under GO dated so and so. Writ petitions challenging the GO were dismissed. Writ appeal filed by the writ petitioner were dismissed. Matter was carried by way of special leave petitions. The same were dismissed, holding that the petitioners are not entitled to claim benefit of GOs of so and so and so and so. The remaining extent of 46.20, which also I placed, my lord, was taken possession, handed over to then APIIC, presently TSHIC, with a GO dated 2/9/2018. The total extent is 470, is in possession of TSHIC in compliance of the judgment of the Supreme Court in civil appeal number so and so.
Yes.
My lord, the learned single judge, my lord, what appears to me, my lord, in my humble submission, is overawed by the fact that those sale deeds were cancelled in 93. Now, my question of my sale deed being cancelled doesn't arise because A, firstly, my lord, they are of the year 2008. Till today, my lord, there is no proceeding known to law or to us cancelling those sale deeds. But, my lord, the learned single judge holds that there was a report of, my lord, an inquiry officer of the year 1985, which went into the question as to whether the agreement of sale.
So this para 29, it says, yes, you have not taken any steps. What is this inquiry report?
Yes, my lord, that's what I was coming to, my lord. If your lordship bear me for a moment more, I'm obliged to your lordship. My lord, the learned single judge takes into consideration a submission that there was a report dated 12/9/1985. It said that the validation of the agreement of sale of the year 1982 requires to be set aside.
Where is 81? Which para 81 has been referred to?
Yes, would your lordship oblige me by coming to page 79, para 31. It is not explained by the learned counsel for the petitioners how another agreement of sale of the same date dated 19/3/1982 surfaced, which was allegedly validated. It is not known as to what form of action. I'm so sorry.
Yes, para 31.
Para 31.
In our copy, it's like we were 52, internal page 52 is first and 51 is reverse. So that's what we were slightly.
My apologies. Well, somewhere I also have that.
31.
Well, may I just place that? It is not explained by the learned counsel for the petitioner as to how another agreement of sale of the same date, dated 19/3/1982 surfaced and which was allegedly validated. It is not known as to what follow-up action pursuant to the inquiry report dated 12/8/2015. Be that as it may, the validation was held to be fraudulent. Or somebody has to say so by an order. My lord, your lordships are aware of the principle. My lord, initially in the East Alloy Company, 1956, 1 All England Law Report, page 855, followed in 4 decisions of the Honorable Supreme Court, 1991, 4 SCC, page 1. My lord, I'll make good if it is disputed. My lord. I don't want to, which, my lord, takes the view, and it's a known principle, my lord, that no order or action bears the seal of invalidity on its forehead.
Ah, yes.
You must take action in accordance with law to have it set aside, and that too within the period of limitation.
Ah, yes. You give that
Otherwise,
citation, we know that principle, but give the citation
yes,
for a day.
1956,
Ah,
Volume 1, All England Law Report,
ah,
page 855. My Lord Justice Lord Redcliffe, as the lordships then were, my Lord.
and this our.
And this was a compulsory purchase order under the laws of England. My Lord.
Yeah.
It is then followed in 1994, my Lord. What? Just give me. '94, page 1. I sent you last evening, sir. Well, this is Jagannath Shetty, if I mistake not, or not. Their lordships have accepted this principle.
All right, you can give it later. Go ahead. Yes. Yes, yes.
That
please
is
go ahead.
reiterated, my Lord, in 1997, volume 3, same principle. I give the page number, my Lord.
And they will give later.
Yes, my Lord, it's here, I have it.
What?
May I have the liberty, my Lord?
97.
The first is 1991, 4 SCC, page 1. Bench of 3 honorable judges.
All right.
We have one more copy. It's due to the other side.
No, so this is this thing for what proposition, that the validity of your sale deed has to be challenged?
So the both, my Lord, for the proposition A. Firstly, my Lord, the validation has to result. If it has to be annulled, it has to be by way of an order. It can't be on basis of an inquiry report. Because the learned single judge himself notices. And, my Lord, I have checked up, there is no order pursuant to that inquiry. In respect of the sale deeds of the petitioners in question.
No inquiry held.
No order. Otherwise, I'll have to be noticed, my Lord, principles of natural justice. Because, my Lord.
No, so in addition, no inquiry held and no notice to you.
No notice to me.
All.
Secondly, my Lord, my sale deeds, even if, my Lord, I take the worst case against me as argued by the private respondents, are a nullity. By saying nullity, my Lord, means nothing. You have to go to. And that report itself, and that is also noticed, say that they will have to take steps to have the sale deed annulled. I'll show that. But may I now place this, my Lord, judgment, my Lord? Page 6, para 8.
They means who? This
the private respondent.
Private respondent has to, this report dated 12/8/15 says.
Yes, my Lord. It's
private respondent has to take action.
Yes, my Lord. May I just point out that, my Lord, where it says. At page 56, paragraph 7.11, small f.
56.
Page 56. My Lord, only for the sake of completeness, may I just place first portion, point 11. It starts at page 54. For the sake of completeness, my Lord, may I just place this paragraph? I may not be said, my Lord, that I've kept back anything, my Lord. Inquiry was conducted in LR number so-and-so dated 12/8/2015 on complaint of one Abdul Aziz requesting for cancellation of validation of registration certificate issued by the district registrar Ranga Reddy in file number so-and-so and cancellation of sale deeds made by the joint registrar Ranga Reddy in pursuance of the agreement of sale dated 19/3/1982. The following findings have been given. So the learned single judge reproduces that at page 56 F. It is not explained by the learned counsel for the petitioners as to how another agreement of sale of the same date dated 1982 surfaced, which was allegedly validated. It is not known as to what was the follow-up action pursuant to the inquiry report dated 12/8. Be that as it may, the validation was held to be fraudulent. The agreement of sale dated 19/3/82 presented for validation was fictitious document and the signatures therein did not tally. Now that's the report. There is no order, my lord, with great respect to the learned singleton, with the signature of the executant. It was obligation of the petitioners to come clean on such discrepancies and clarify serious dispute regarding to title and the title of their vendor. My lord, it will shift on the other page, my lord, because the page is by mistake. The petitioners miserably failed to discharge their burden in spite of serious objection raised by the state and private respondents. The fraudulent actions of the petitioners are apparent from the face of the record by not filing the sale deed. Now, this is also with great respect to the learned single judge, incorrect, my lord. They are found, my lord, in present paperwork at pages 136 and in the record that I have seen, my lord, pages 54 onwards. By not filing sale documents, by not disclosing validation certificates which were later held to be fraudulent, flow of title, dismissal of suit number OS 248 of 1991, etc., the petitioners have suppressed vital information and the writ petition lacks bona fide. Well, completely going beyond the scope of, my lord, the writ petition is my respectful submission, my lord.
Yes.
My lord, and my lord, if this had to be gone into, somebody ought to have raised it in a properly constituted proceedings my lord, instituted within the period of limitation between the right parties. My lord, one more thing which I want to invite your lordship's attention is when I came to this court by way of this writ petition, my lord, whose order is under appeal, a solemn statement of the learned advocate general was recorded while granting me relief. Now, please peruse that. That statement says, this is recorded on 12/9/2016. The learned advocate general submitted.
Where is it?
Look, I am reading from, and there was a writ appeal against that order also. I have a copy, my lord, which is not part of.
Otherwise, we won't be able to refer. Is it on record?
Yes, 268 is on record.
216, Mr. Prasad.
268, volume 1.
268.
That 268 will be volume 2. I'm so sorry.
Volume 2.
Volume 2.
268.
It starts from pages 233. Followed lordship will notice with petition number 30855. Order at the bottom of the page 268. The learned advocate general submitted that they are going to protect their 470 acres of land by way of fencing. So it was not even their case then, and it has, my lord, I have checked up meticulously, if I may use that phrase, my lord, with your lordship's permission. It is, I don't find their case, A, that except these two orders, which total up to 470, 2006 at page 222 and 29 2008 for the balance 46, my lord, there is any other order of allotment. 2, there is no case that this 99 acres was subjected to any proceedings under the ULC Act, or that it was so rightly or wrongly declared as excess and rightly or wrongly taken possession of. The only case, my lord, of the state was.
No, this was declared surplus, 99 acres, possession handed over subsequently to the landowner.
It was declared surplus under Agricultural Land Ceiling Act, it reverted back. But, my lord, I must, my lord, admit, and I cannot get out of that legal position, that it had to be subjected to ULC. But the fact of the matter is, it was never so subjected.
All right.
And there is no 10.1, 10.3, 10.5 in respect of these. So what happened was, my lord, when the Parliament passed the Urban Land Ceiling Regulation and Repeal Act 1999, it had to be adopted in a similar fashion. That comes to be adopted. 2 days before its adoption, 46 acre 46 acres out of the 99, they straightway issue, my lord, a notice under 10.5, 10.6. But even then, my lord, 53 acre remains, and that's my case. But with respect to even that 46, there is a finding by the learned single judge in a cognate matter, which is writ petition 8543, my lord.
That's not the subject matter of this appeal.
That is, my lord, pending in appeal before your lordships.
Whatever. Yes.
Therefore, my lord, my respectful submission is, my lord, A, that, my lord, notice having been issued, your lordship may consider my prayer for admission of the appeal and, my lord, continuation of the interim order, which starts from.
No, we thought that we devoted so much of time to hear you finally.
Correct. Well,
otherwise, we would have admitted in 1 second and heard the other person.
Well, I'm sorry.
1 hour.
I take back that, my lord. My lord, the prayer therefore is that the learned single judge has gone beyond the scope of the writ petition, my lord, in adjudicating the question of title, which A, could not have been raised.
This what you would have done, your colleagues would have done submission, so we are not required to note, right?
My lord, and for, my lord, possession, I rely upon
so beyond scope of in the writ petition in adjudicating the title. What is the second submission?
Second submission is, my lord, possession. Your lordships have consistently held that, my lord, possession even of a rank trespass is to be protected unless there is, my lord,
yes,
authority of law
can be taken only in accordance with law.
Right. So that is 1992 supplement 2 SCC, page 29.
Supplement 2 SCC 29.
Page 29.
All right. Next.
My lord, followed in 4 judgments, my lord, including, my lord, the famous judgment of, my lord, 2004 1 SCC Rama Gowda, 7, 2004 volume 1 SCC 769.
Paragraph
7.
Yes, next. All right, next.
My lord,
submission.
My lord, the last submission is that, my lord, what was under challenge was the arbitrariness of the action of the TSHICC. My lord, it responds, or it is an authority within the meaning of.
Third is you said that it is taken in violation of interim orders.
My lord,
subsisting.
Yes.
Interim orders
subsisting.
Yes. Subsisting interim orders. What else?
My lord, therefore, my lord, Marfatia 1989 volume 3 SCC. Page number 293. Is, my lord, that the writ court under 226 extends to every arbitrary action of the state. It's of course your lordship's discretion, my lord. I cannot say.
No, you should have cited this, that question of title cannot be adjudicated in a writ proceeding.
Correct, my lord.
Which paragraph? Which para?
Your lordship may oblige me and please come to
para
22 at running page number 304, 21 and 22.
21.
Yes. We are unable to accept the submissions. Being a public body, even in respect of its dealing with its tenant, must act in public interest, and an infraction of that duty is amenable to examination either in civil suit or in writ jurisdiction. Our attention was drawn to the observations of this court in Radhakrishna.
So, public authority, even in respect of an activity in contractual sphere, is amenable to judicial review.
And here, if it wanted to take possession, my lord, even, my lord, therefore, the learned single judge goes on to hold that I don't have a title. By entering into dispute, interse between me and the private respondent, which was not the, my lord, remit of the writ petition. And
you and private respondent, which respondent?
Well, private respondents are large number, starting from, my lord,
10 to 31 to 35.
Yes.
All right. That's it.
In fact, when they came forward initially, a lot of other people also jumped into the frame. But principally, this was the writ petition.
All right. That's it. Anything else?
My respectful submission is, my lord, that this be, my lord, set aside, my lord, and my possession be protected, my lord, leaving it open to them to take appropriate proceedings, my lord, in a manner known to law.
Yes, Mr. Prasad.
I will straight away go to the page 222, which my friend has also read, not to just to bring it to my.
You are appearing for?
It's 222.
No, you are appearing for whom? First tell us.
Official.
Respond number 1, right?
All the official respondents were on the writ petition. I just bring it to my lord's notice.
R1, TSHIC.
TSHC also, and the state. Official respondents were not including
Official
TSHC.
1 to 5, right?
Yes.
The state was later added as the party.
1 to 5. Yes, please.
22 also. 22. 22. R22.
R22.
Is the state.
In writ appeal, they are 1 to 5.
22 is the state principal secretary, revenue department.
And not for 1 to 5.
1 to 5 also.
1 to 5 and 22. Yes.
But I would just bring it to my lord's notice, but the subject matter of writ petition was 53 acres. 53 acres of land.
No, but you have seen this. He read to us the prayer clause.
But one
So therefore, I mean, two things. We will hear you, of course. We have given him 1 hour's time. We will give you that time also. But see, the only two things: the scope of the writ petition, the salutary principle question of title cannot be gone into writ petition. Thirdly, even if assuming he is a trespasser, action needs to be taken against him in accordance with law. These are the, in these backdrop of these principles, please go ahead.
But I would respectfully submit what the writ petitioner seeks.
And an order passed by the division bench, as pointed out by brother, permits you to take recourse to law.
Yes.
Right? And there are two interim orders like one.
There is no dispute with regard to 470 acres of land.
No dispute.
Which is vested in the state by virtue of the urban land ceiling proceedings.
Yes.
But these urban land ceiling proceedings culminated in favor of the state by virtue of the dismissal of the SLPs filed before the Honorable Supreme Court.
You went, Mr. Prasad, as we understand, what you are trying to say is that his land is included in 470 acres.
It is. But I would only say, Marat, my reason for appearing before the learned English judge was to protect the extent of land which I am in possession of. Those orders have attained finality by virtue of the civil.
He is not challenging.
Supreme Court dismissing the SLP as against the private petitioners therein. But this in
these petitioners SLP has been dismissed. Against what order?
Including those SLPs, the Honorable Supreme Court was pleased to record the fact that the TSHIC is delivered of possession, including the possession was also recorded in pursuance to the urban land ceiling proceeding attaining finality. Kindly see the prayer in that context, but now it would be virtually reopening the proceedings which have attained finality, which is also observed by the Honorable Supreme Court. In a SLP filed probably by the other petitioners. But here is a case, my lord, who according to me.
These writ petition, he told us that he had filed 2 petitions which are pending.
Yes. But right. According to him, subject to what your lordship would say.
Yes, no. So tell us facts. These petitions had earlier filed a petition.
No. Earlier predecessors in title were
predecessor in title.
Not of this petitioners, not predecessors in title, where the declarants had sold to several people.
No. So see, as we understand, the land, they are not staking any claim on the land measuring 470 acres allotted to you. That's clear to us.
That interest is safeguarded, my lord. I'll be safe, my lord, because state is happy with the possession which is taken.
Correct, Mr.
Lordships can record my soul.
Record that.
I claim no interest and the land purchased by me forms no part of.
Doesn't claim any interest
in land at measuring 470 point. I'll give the exact figure.
Acres.
This is the extent.
1 minute. This concession coming to your aid. We are recording this. Doesn't claim that land measuring
470.33
acres
comprised in survey number 83/1.
83/1, which has been allotted to
Malot with 2 separate orders dated. So I can just make my statement precise. Dated Malot 13/2/2006 GO number 161
and
GO number 107788.
But this
29/2008.
29/2008.
But this is also, I have stated in my counter at page 297. Page 297 of the book.
So you can be now, this thing, we are recording his submission that the appellants do not claim any interest or title in respect of land 4077 acres of survey 83/1 allotted to you by government orders dated 13/2/2006 and 2/9/2008.
That should be also see para 30 of my counter, just for my lords.
Para 30.
297, page 297.
Yes. So that is not under challenge.
That
Now,
therefore, I had appeared before the Lord single judge Milord to safeguard the interest of the state. Thereafter,
so this is, we will record his submission, correct, Mr.
Lord?
Yes. Yes, please. Yes, you are appearing for 10 to 50. 30. Yes, please.
I will say that we are in position of land. And in the options of $100 of the land, I will go out of both time to say when the writing is effective.
Yeah, yes.
My own these people who are foreigners behind no idea. They have I think that
So they have no title and no cause of action to file writ petition.
I also documents before the start of the not restricted. And then let's say
No, you have filed revenue records pertaining to 80 years. 73 years. No, you realize 73, just, no, lighter weight, Mr. You said 80 years, so we thought probably we have not completed this thing. 73, fine. 73 years to show what?
Present respondent before your thoughts of private respondents or owners of the
Which land?
respondent.
No, owners of which land? Because
83/1 or 83/2?
Acha, part of which have? In survey number 83/2. Yes.
Exercise the precision part like a free for. Make something to your large. Then like lot of people come before the sound out. First question they ask them for me.
Yes.
If you are authority.
Of which one?
So let me get to expect something that findings from the don't
And no locus.
because take out all their safety. Well, they say this. Say
Better time. Learn it singly.
that they don't say that the governor their vendor seven daily, but since the property under the state it has not seen that the
Well, purchase the land under MOU dated what date? 93, 92, 82. Yes. Yes. Ah. One minute. We wish that we could have done the course of stenography also, so shorthand. No, correct, we appreciate. No, we appreciate. I mean, appreciate the clarity with which you are putting forth your case. Yes. Didn't obtain sale deed, therefore, under section 64. All right, yes.
Section 40 of the that any document is compulsory by section 20 of there. The laws of section 90, 49,
Followed. So which agreement, which document is sale deed is registered or not? Oh, so that we have got that their vendor did not have the sale deed in their favor, therefore it could not have this thing. There's no title vested in him, the society, and therefore it could not have conveyed any title to petitioner. Got it? Yes. This agreement, you have the date? 19,382.
Point out by like this. The 90 it's away out of now being claimed. All under the custody and position of the government. Being surplus land of the land from year 97 to 1990.
70. Which year? 70?
1990. So, when the daily itself is approved, vendor is not they cannot convey. That's what the property which was said that the government were vendor cannot be released to the that's what the was under the custody of the government being except ban and dedication tax. So, in position, and other private these are the inquiries.
Yes.
One is the person who I think so in Second page, whether is it? It's very direct.
Para 28 to no. Para 28 to 33. No. This indulgence has been given to him because he is an outstation counsel. So that's why. Otherwise, yes. Yes. No. Yes. No, I come from a court where always an outstation counsel is accommodated on the day he comes. We wish he could have been shorter in his submissions. Yes, please. Yes, please. 33. Yes, correct. Court has not declared the tie.
So, the next maintaining. Because I yeah. See, Bala requests so
and in his writ petition, the findings are in para 28 to 33. Yes.
Then the abundance in concept. Then one then two days. And they have been cancelled. The government said that they are divided. Questioning that they are not. What's their current
Cancellation of what?
Say,
Who?
Say, it's
No, but he said that the proceeding in respect of this land also ought to have been initiated under ULCR, but that was not done. Correct?
These are all savings, distance are savings. They cancel all savings, 500 savings, but one savings. In the year 1970, they have sent all the savings.
Which paragraph single judge say? Page 37.
Learned friend can oblige me by saying that all those sale deeds were with respect to 470, not with respect to this land.
So this is the findings. It's not. Findings 19 starts from 28 and page 18 to that.
No, but you agree that these are nothing to do with petitioner.
Correct.
Petitioners were not parties, right? Yes. Yes. Now, which paragraph you are reading, Mr.? 36. It is relevant to mention all sealed deeds.
So, saying, already cancelled and tested by the amount of now, if there don't submit up, no way, no way. What
That we got it. Yes, you have said that the court has not declared anybody's title. The court, in support of their claim for the relief prayed for in the petition, asked them to prove the prima facie title, which they have miserably failed to prove. Yes. All. No, please, take anything else, please. You have been brief to the point. We really appreciate. Anything else, Mr. Kaur? How does it matter? He is the landowner. Yes.
He goes before something start or mandate in the year 2006. What interesting saying that
These are Sada Bainama. So then they got it validated, agreement of sale was got validated. Section 17 of the registration. The validation took place in 2006 while the agreement of sale is 1992. It took more than 25 years to get it validated. To get it validated by which after registration 17 there was no registration. So those are agreement was required to be registered at validated only in 2007. Validation is only for payment of stamp duty. That does not give the defect of registration. Under section 82 agreement unregistered. Got validated in 2006. Got validated in 2006.
So, for stamp duty.
That is only for stamp duty. Validation for only stamp duty. Second, it does not prove the defect under section 7. Volume 5. Volume 5.
Yes, definitely. Easy petitioner.
This agreement of sale is
by Bhavana Cooperative.
So, add, so add no locus to seek validation of this thing, agreement. Correct. Fine. Yes. 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 Paragraph number which of citations? Please tell us. Ah. Ah. Para. Yes. 1 minute. No. Can't. 1 minute. We are noting it down. Yes. 2012. 1 SCC. 6. Hmm. What is the citation? Like what is the proposition? Same, right? Same. Agreement to sell doesn't this thing confer a title. Same proposition. Same or different? One is enough. One decision also will bind us under Article 141. Mr. Senior Counsel. One case for one proposition enough. Don't multiply authorities. 2010 volume 8 SCC. Page.
2010 SCC 383.
383. Para 60. All right. Yes.
Yes.
Yeah. Which paragraph? Validation cannot. Can't cure the defect of non-registration of a document. Yes. Correct. 2004. Para. What void? So void document means what? He had to prove. Aim to prove. He was required to prove his title to enable him to seek any relief. Yes. Not reported. Okay. Please pass. What is this?
95.
Where is it given? Where is it given?
33, 34, 38. 45, 46, 61.
No, citation.
30.
2030.
SCC 39. No, but they had filed a suit for a specific performance. You said dismissal.
Same bhavana spirit,
No, we want to know whether in respect of the land, he is now presently claiming on the strength of 7 sale deeds. You are saying it's void ab initio, all that. So that is, but the suit for a specific performance of contract was in respect of this very land covered under. So despite after dismissal of the suit, Bhavna Society, no, but that society is not challenging the sale deed executed in their favor. Parties to the sale deed have not. Correct, may not be necessary. Kishore Samriti. Yes.
But nobody should take chance with divorce.
Yes.
They all have. They are no. Did not exclude the law. They are all disclosed to the report. And sometimes people don't say that. It is both points. Somebody not do something. Go back to the country back. And say that God will divide. We will not hear. We will not hear the matter on this. That will be done.
Oh. Yes, thank you, Mr. Thank you. Mr. Prasad. Nothing, right? Your interest is protected.
I'll just.
Yes.
My friend said, when the documents are not valid documents and I am not concerned.
No need. No need to challenge.
I follow.
Yes.
23 to 26.
20. 5 minutes, Mr.
Yes.
16 to 21. Adopting. Who else?
7.
Respond number 7.
8 and 9.
You adopt.
Yes. I'm telling you the failing.
Because we have given development.
Who is supporting? R8 and R9 are supporting. R8 and R9.
Yes.
All. What about R7, Mr. R7 adopt the submission, right?
28, 29 October adopting normal.
28, 29 adopt the submission. Yes, please.
Says they are trying to evict, demolish,
and
fencing. There is no structure, there is no compound wall, there is no building.
No structure, no compound wall.
Yes. Did not given today.
Oh.
Photographs of that one. Yes. Just keep that.
Mr. 5 minutes.
Yes. My learned friend said that there is no declaration of title by the learned single judge against me. Page 85 is the answer, para 38. Last 3 lines. 4 lines.
Para 30.
Para 38. However, as per observations in
Which
para
page?
page 85, running page 85,
Ah.
paragraph number 38, he referred to paras 28 to 33 and said that it is only prima facie, there is no declaration. That's the submission that I heard. However,
Your title, it has been held that you don't have title.
However, as per the observations in para 28 to 33, supra, the petitioners in writ petition 30855, that is me, 7 companies, did not acquire any title, and the petitioners herein and so are similarly placed. That is second. So that, my learned friend, with respect, is not right.
Yes.
2, when I came to the court, I came with a specific averment, and which was against the Telangana State IIC. And that averment, your lordship will find in paragraph number, my affidavit in support of the petition starts at page 91. Paragraph number is 8. I further submit page 94, running page 94. I further submit that both orders are in knowledge of respondent number 1 without reference to the orders passed by the Honorable Court on 11/9/2016. In the early hours at 5 a.m., the officials of the respondent number 1, along with third respondent, I name them not by designation, Seri Gammala Mandal, came to the land of the petitioners unauthorizedly and removed temporary blue sheet fencing partially and tried to forcibly dispossess the petitioners. The petitioners have deployed the security man at the land belonging to the petitioners. Respondent number 1 officials, along with officials of respondent number 3, have threatened security personnel of the petitioners with dire consequences. There is no denial to this. Their affidavit starts, your lordship will find, at page number 270, affirmed at 273 by Mr. Raghunandan Rao, District Collector.
R1. No denial by R1.
District Collector.
No, R1 is not District Collector.
No, second respondent.
All right. Yes, then.
Except this, there is no other affidavit.
All right.
Therefore, my lord, my learned friend saying,
affidavit.
No.
So these people are pleaded in.
I'm saying I'm sorry. I should have qualified it by saying no other affidavit on behalf of official respondents. I'm so sorry. I stand corrected. My lord, their whole attempt was to submit. My lord, I have come with a frivolous petition. I say I came with a specific cause of action, giving sufficient details, no denial of that. They jump into the bank. My lord, I tell your lordship why they do this.
So then,
I tell your lordship,
private respondents had filed counter.
Yes, by District Collector.
Counter. Filed. Yes.
My lord, I tell your lordship why, my lord, they have come in. My lord, I can discern it, my lord, and I wish to place it for your lordship's consideration. But look who's talking about fraud. I tell your lordship. They are landowners. They executed registered power of attorneys.
Whose favor?
In favor of, my lord, 3 persons who were partners of Venkateshwara Enterprises.
When, what is that registered power?
That power of attorneys of ET2. Different dates, my lord. It's there in my list of dates.
No. Is it there in the petition or anywhere in the pleading or just?
Yes, no, it is there. It is there.
Where do we find it?
No, my lord, when I tell you, it's admitted fact. I'll just give that page number in a moment.
Please give.
Yes. My lord, they enter into a transaction on basis of a, my lord, agreement to sale with Brown in 1982. There are 2 agreements of sale, 125 acres and 99 acres. Both executed in favor of Brown. All that my learned friend said, which went right up to Supreme Court, was in respect of that portion which was part of 125 acres and which was part of land of 470 acres declared as excess. Well, my sale deeds were executed in respect of other land which was never subjected to ULC proceeding.
Yes.
So, my lord, 2008, my lord, then comes the decision of 2013 in the Supreme Court in respect of those lands. By the time they had lost.
We need not go into this.
Correct.
You began by saying that prayer clause. We will consign our this thing whether you are entitled to that relief or
correct. And I was only against them. I was only against them with these averments, and these were never denied. So, my lord, any private respondent coming and raising is not, my lord, in my humble submission, a ground to dismiss my petition.
the suit getting dismissed. In the writ petition, is there a mention about the suit filed being dismissed, suit for specific performance?
I have never filed the suit. If there is
not your vendor, Bhavna, is there any mention about the suit being filed and getting dismissed? Suit for specific performance.
I must admit.
That has not been mentioned by you in the writ petition.
That was not in respect of these, my lord, 99 acres. That suit, if your lordship see, even according to their affidavit, is with respect to 125 acres.
No, what you see, 470 is 83/1 in respect of the land that is fallen to
And
government.
in that 470 was 125.
So, because I'll tell you, the difference is 470, initially it was 430 or something. That is why 125 came. The difference of 125 came, for which specific performance, suit for specific performance was filed by Bhavana Society. That they failed in that suit. Now that has attained finality. They did not challenge or take any further steps. Now thereafter, this 430 or other thing became 470. So that is how the balance 90 odd acres came. Correct? Now it is the same Bhavana Society which is now saying
Under different agreements of sale.
claiming and executed a sale deed in your client's favor.
Lordship. But under two different agreements of sale.
Same day.
Lordship may only bear that in mind. But my lord, one important fact is that the government claiming the entire land to be theirs filed a suit 71 of 2000. That was decreed. That judgment was set aside by division bench of this honorable court and they have lost title up to Supreme Court, my lord. That Supreme Court decision I have placed on record. But my learned friend said that we were never in possession, frivolous litigation, just peruse 260, because this was part of the record. 260 is my lord, fencing, board, and my construction.
All right.
Along with my lord, Bhumi Pujan being done at pages 261, 262. And this was part of the record. And I was only against my lord there.
No, 1 second. If you are claiming these constructions are made, have these been made by obtaining any permission or?
No, these are temporary constructions. But this is to prove possession. And it was never my case that.
Why I am asking is, even for a temporary structure, you need to have permission. Even for a shed room today, in Telangana, today for a construction, a compound wall,
This is where
permission.
My lord, if fencing doesn't require permission.
Fencing, I'm only talking
Page
about
260. My lord, there is a room in respect of which, my lord, there are, my lord, my security men. This is the room.
But whether does it have a permission for, have you obtained a permission for construction?
My lord, I have no instructions on that, my lord, but it is not a pakka construction.
No. That's what I'm saying.
It's a security cabinet.
I'll tell you one thing, maybe my lord does not know. For a thatched roof in Telangana, you need a permission.
Correct.
This is the position of law.
Now,
For thatched roof, you need a permission.
Building has got a very expansive meaning. Building has got a very expansive. definition.
My learned friend, decide upon your lordship's court judgment, my lord.
Thatched roof also they need a permission.
Before
can I just give the paragraph numbers of the very same judgment by your lordships, my Lord Justice Vinod Kumar R. Pati, my lord. I rely upon the very same judgment, paragraphs number 37 to 39, but the most important are two paragraphs, 40 and 40.
Which judgment?
2021 SCC Online TS, Telangana State 1014.
Online 10?
1014. Well, the same judgment which my learned friend relied, but he relied upon other paragraphs. But I read this. Equally, it is well settled that a person in settled possession of property is entitled to retain it, and even a rightful owner can be injuncted from using force or taking law into his own hands.
Compilation, this is two cases. Okay. Yes.
40, 41 and para 56, my lord. My lord, this judgment of 2006, which he relied upon, my lord, three honorable judges, Justice Rao, my lord, speaking for the bench. But this arose from this is 9512 of 2003. It arose from a suit of specific performance.
That will be the other one. AL2 decisions. We make a this Yanala. That is Yanala Malleshwar.
No, not three judge, but it's a division bench, right?
Bench.
Not three judge. Division bench.
Malleshwar is
Justice Bilal Naski, Justice BVS Rao, and Justice G. My lord, I may be making, I'm sorry, my lord, in name, I found a comma, my lord. I'm sorry. I was. It is three, my lord.
Is it a full bench, Mr. Srinath? Is it a full bench?
2006.
It's only DB. Three.
I'm so sorry.
Nala Malleshwar.
Full bench.
Any
Full
mistake
bench.
is completely unintentional.
No. Full bench is, this is the judgment 2000.
9512, my learned friend referred to writ petition 9512 of 03 para 32. That is reported in one paragraph. Yes, please.
We have got the citation. You, which paragraph, what proposition? Please tell, Mr. We had given you 5 minutes.
Yes, he relied upon para 32. Completely different set of circumstances. His contention is that for a sale deed or to acquire title, you require a registered sale deed. Bhavna did not have registered sale deed. That was his submission.
Yes.
But I respectfully say that if he wants to challenge my title, which is flowing from my sale deed of 2008, he has to go and challenge it. I, my lord, rely upon section 53A that in part performance, Bhavna was put into possession.
That Bhavna being put into possession, your own document which you have referred to has been referred to because government gave back the possession only later. So you could not have claimed.
I answer that straight away. In law, there are two possessions. One is de facto, one is de jure. Bhavna always had the de jure possession in view of the fact that when it was declared excess in 1976, the judgment of this honorable court in 77 declares the law as it ought to be on 17 to 1976.
Physical possession is different from.
It's our case. It's a finding recorded by the urban land, by the agricultural land tribunal. Possession was not taken after notice. So, it was only a claim. It was a paper possession is my respectful submission. The judgment of Supreme Court is 2008 14 SCC 171, which takes the view that once there is a declaration of law by the court, it will relate back to the position when the law was enacted. But the declaration of this court that ALC Act will not apply will therefore relate back to 17 to 1976. Lord, I am very grateful, Lord. And Lord, I am indeed, Lord, beholden and obliged to your lordships for accommodating.
You take more than the time intended.
Yes,
Only one.
Please.
Your lordship,
Please. Please.
Page 44, paragraph number 6.13. Paragraph 6.13 at page 44 of the volume 1. Your lordship, kindly consider. They have taken loan and criminal cases were registered. That is the.
Who was the petitioner?
Company had taken a loan. All this, it is becoming free for all.
More than 25 crore, a CBI case was registered that was mentioned in this paragraph. It's not brought to your lordship. That's why.
All. Para 6.13, page 44. Your respondent number? All right. We definitely will take into account this. Thank you. Mark everybody's. Mr. Prasad, finally, nothing else to add. We believe. Mark the presence.
Grateful,
reserved for judgment.
Once again,
heard. Send it.
I express my gratitude, my lord, for the indulgence granted to me.
No, the amount of time we spent on this case, we felt that.
I am obliged, indeed grateful to your lordships.
This 16.
Look me the citation, Rashpate.
Yes. Yes, at least begin. At least, yes, call him and tell. Yes, call the other case.
Pass over not.
Pass over.
Where is your special GP?
May we have your lordship's permission to leave?
Yes.
Full tradition. If the court time is over,
Yes.
the court is not in session, you must take permission.
No, yes, reserved for judgment. We have told. Yes. Yes. Mr.
My lord.
Yes, yes. You have gone through the counter.
I have gone through the counter, blood. I will make my substance so far as R3 is concerned, because R3 is insisting was ordered. Now your lordship can see, in fact, he has been paid more than the contract amount.
Okay.
And he wants excess.
No, but tell us the facts. Now we are hearing it finally, right?
Vicious accusation.
Let it, you will have.
Yes.
Yes, please.
Now my submissions are 2-4, my lord.
No, please tell us the facts. What?
Yes. You know, initially, according list of dates, your lordship can see, yes, my land friend has given the list of dates.
Hmm.
So 15/10/2015, the government has
Mr. Govind Reddy? Is your client willing to give a bank guarantee?
My lord.
No, I am only asking.
To be very honest,
No, why we are asking is, we will like.
No, my lord, we don't have such instructions.
That is why we are asking you whether he is in a position to give a bank guarantee so that we can examine the issue later.
My lord, my colleague has just informed, my lord, it is not feasible, I feel.
Fine. Then
my request is, your lordship can see the contract award in their favor. Now, the case of the respondent R1, who has awarded the contract, initially the contracts were awarded in favor of R4 and R5 for construction of these houses. But because they were not able to complete the work assigned to them, now the present contract is awarded in favor of R3. Both the contracts clubbed together. Now I request your lordship kindly see 84, page 84. The contract award in favor of R3. This is dated 25th of November 2020 in favor of DEC infrastructure and projects, that is R3. But there you will kindly see second para, whereas the Greater Hyderabad so and so infrastructure has this Mahasanpalli village number so and so, Maheshwaram in Maheshwaram constituency in GHM. Because this you will kindly see shifted from Gattupalli village. Initially, the contract was awarded for construction at Gattupalli. And without any further notice, that was shifted to Mahasanpalli. And the contract is awarded, and contract value of can last sentence 82 crore 64 lakh 79,803. This is for the balance work left by R4 and R5.
Construction Gattupalli, original. Gattupalli, for construction of 2 BHK house, shifted to Maheshwar. That is what Mansanpalli.
Yes, Mahasanpalli.
Gattupalli to Mansanpalli.
Gattupalli to Mansanpalli in Maheshwaram. So when the site was changed,
but Gattupalli is also in Maheshwaram Mandal or
no,
other Mandal?
Ibrahim Patnam.
No, which Mandal? It is also in Maheshwaram Mandal only. I am telling, please take it from.
Yes, right.
Then, you will can see the contract amount to 82 crores 64 lakhs 79,803.
60.
Then your allotment kindly go over to class 8, page 85.
Class?
Page 85, class 8, price adjustment. No price adjustment shall be done for implementation of two-bedroom housing and infra works program in Telangana state in accordance with the conditions so and so. So no price adjustment. Then your allotment can be class 12 also. The contractor shall not be entitled for any other sum whatsoever except the amount mentioned above. Similarly, your allotment kindly go to other contract at page 88. Page 88. Here also the same date. This is also a case where site has been shifted from Manganur village in Abdullahpur Mandal in Ibrahimpatnam. And the contract amount is 80 crores 38 lakhs and odd. Now in this also we not class 8 and class 12, same class are there. So the amount payable under these two contracts are 80 crores 38 lakhs and another one is 82 crores 64 lakhs. Now your allotment kindly see page 82. What are the amount that have been paid? Under the Right to Information Act, they provide this information. Page 82. But one work 89 crores 71 lakhs has already been paid, and other work 86 crores 22 lakhs. That is much more than the contractor amount.
No, but how do you read clause 8? Please tell us.
Yes, class 7.
8. Price adjustment.
Good, class 7.
Clause 8.
Class 8. In adjustment, no price adjustment shall be done for implementation second bedroom, two-bedroom housing and infra in Telangana state in accordance with the conditions as per GOMS number so and so.
What does it say? GOMS number so and so and GORT number
128/2007.
So what does GOMS number 10 and what does 107 say?
No, if this is to be read along the other class, so whatever is the contractor, it can't be paid more than that.
No, what does this? Is there a complete bar under GO10 and GORT 107 is the question.
No, for that, your allotment can see. First, your allotment can see no. Kindly see the amount that have been paid. I will come to that. I'll come to that.
Price adjustment clause in the agreement.
Yes.
I am only asking, does it, there is a bar under GOMS10?
Because the very contract itself says that no amount whatsoever other than the contract amount can be paid. No escalation.
You are relying on clause 12.
Yes.
But there is also a clause number 8, which provides for certain adjustments. So clause 12 has to be read in consonance.
I'll come to that.
Now I am asking that question. Yes. Is there a bar under GOMS number 10 and GORT number?
No, but this is 117. Because in relation to balance work that has been entrusted to them. First submission was even at the time when they changed the site, at that time they could have floated different tenders. And then second submission is, what you say, because the failure of R4 and R5.
Yeah, so what are your submissions? Number 1?
Number 1 is, without calling for tenders, the contract could not have been awarded in favor of R3. When the contracts R4 and R5 are close.
couldn't have been awarded to respondent number 3 and 4.
Yeah, 4 and 5. R3, contract is awarded in favor of R3.
No,
And
initially,
failure of R4 and 5.
initially it was awarded to R4 and 5.
R4 and 5.
Because they have failed to perform, it was awarded to R3.
R3 without conferring it tender.
So, even if a contractor fails to whom a contract is awarded,
Yes.
submission is this. Originally, it was allotted to 4 and 5. They have failed, so they should have called for
Yes.
balance work by another tender. Is your understood?
And even I will show you that they risk and cost, not just they risk and cost of R5 that have been awarded.
All
We
right.
do not know whether you have not placed anything on record to show that agreement
Yes.
had risk for
But in fact, you last can see these contract awarded also do not include those copies. There is no reference to those contracts. This is totally independent contract. There is no reference to the contract in favor of R4 and R5.
Fine. So,
Because
second submission is,
then you are not
I have got it. First submission is
the
with
payments have already been made in extra. Payments have been made in extra as evidence by their own communication at page 82. In more than the contract amounts have already been paid.
this is a PIL, right?
Then we are page 26.
No, we are just asking.
Only one sentence I read and page 26 is automatic analysis. Probably there is no counter. Page 26.
Yes, yes.
Because you automatic analysis affidavit page 26. Running 26. It is pertinent to state that as of date, second respondent is providing subsidized cement to cement manufacturing companies, TMT at 230 rupees per bag. TMT steel, the most important item, the respondent is paying the TMT steel bills of responsibility as per the current active market rate through its government order number so and so. And furthermore, the sand, which is the most important costly ingredient in building works, which is very costly in Hyderabad, has been supplied by the respondent one to respondent at free of cost. It is admissible to say the steel, cement, and sand are the three most important companies which share 70% cost in 2 BHK building works, and the contract of third respondent, though executing the work as the flag of gold to tender work, but actually gaining excess amount of 38% against the agreement. This is the specific allegations made, which has not been denied by R1. Now, therefore, my submissions are, this is totally arbitrary. So far, the Supreme Court nomination is not such a contract which cannot be carried out by anyone. Suppose there is an expert. Maybe award a nomination because it's not, it doesn't require any such expertise as it is. It's totally arbitrary, shifting from one place to another without there being any provision for that in the original tender. And tender is not by a party to the contract awarding in favor of R3. They say it's only balance work and the contract price is also there. He has already been much more.
But this is this work does not require any expertise. But we are sure that none of us nor petitioner could have constructed these 2 BHK apartments, right? Petitioner also could not have constructed. Neither one of us could have constructed, right? Lighter vein, Mister.
None further way.
Yes.
In fact, to get a building construct itself takes hard.
Yes, yes.
So these are only submissions.
All right. Thank you. Mr. Yes, Mr. Reddy.
Well, the sum and substance of my friend's argument is that that the contract was awarded on negotiations and nomination. It would have rather awarded through tender. Your Lordship may see. I agree with my friend, to the extent that yes, he's got Supreme Court from time and again it said, why it is necessary for calling the tenders is because to fetch higher price. First reason is fetch higher price. It will be more fair and transparency. In cases where the state is generating revenue, when its case is maximizing the revenue or making some income out of that particular contract. But In other contracts, my lord, in all other contracts, my lord, other modes also are preferable, provided if it is arbitrary, irrational, violation of Article 14. Now, my lord, you may not come against one aspect, my lord, you may not dispute saying that, he's a competitor to me. Second thing, my lord, irrational. My lord,
Not a competitor.
He's not a competitor, just public interest. Therefore, my lord, Article 14 will not apply. The question is irrationality.
Which is the judgment on which you are placing reliance?
Well, I'll just take your lordship to that judgment. I'll just tell you, my lord, he may harp on arbitration, but irrationality, my lord, means absurd to succeed the object, my lord. He also doesn't dispute because we have successfully completed the contract. So the question is arbitrary. No reasons aside, reasons aside just doesn't justify the action. My lord, your lordship will see here.
You have completed the contract.
This amount fixed.
Completed the contract.
We have completed the contract. We have handed over the project in the month of 22. My lord, already beneficiaries have started occupying the building. No, my lord, in the month of January 2023, he files this bill. Before that, my lord, one bill was already dismissed. One petition was dismissed. Another petition is pending. Now he comes up with the fourth bill before your lordship.
No. So which writ petition is pending? Questioning your contract.
Yes, well, yes. Some of the subcontractor has challenged it. That also I mentioned in my written submissions. Your lordship will find that the chronological events and synopsis which I filed at page number 3.
Yes. Yes.
Writ petition number 218. Sorry. Sorry, I'm sorry. That is dismissed. Writ petition number 782 of 2021 filed by RV Construction. He is a subcontractor of respondent 4 and 5. He filed it, challenging that. That is pending, Lord. Before that, my lord, there are two other people who challenged my awarding the contract to me. That was dismissed. The bill was also filed, saying that you take action against respondent number 4 and 5, penalizing them. That was dismissed. And this writ petition also pending, seeking somewhat similar or identical relief what it is sought in this bill now.
Both are dismissed. Bill 258 and WP 21807 were dismissed.
Yeah, that's correct. We filed in our material papers along with the counter file. Now, as far as these, my lord, there is certain amount is fixed for constructing each flat, my lord. Each flat supposed to be constructed. There is no dispute that we have constructed 2,412. 2,412 was constructed at the rate of 7 lakh rupees plus 75,000 for infrastructure facilities. He conveniently avoids saying that, my lord, it is GO. In GO, it is fixed, my lord. GOMS number 10. Which is filed along with the chronological event, dates and events.
8 to 12, page 8 of it.
Well, initially it was 5,30,000. 2,412, 7 lakhs is coming about 1 crore 68 lakhs, my lord. Additionally, 75,000 in urban areas. That is additional for providing infrastructure facilities. It is there part at page number 9.
Which clause you are entitled to these amounts? GOMS.
GOMS number 10, let with 3 million. 10 million, what happened? They fixed 5,30,000. They enhanced it to 7 lakhs in GOMS number 3. But infrastructure facilities, my lord, that is GOMS number 10, they retained it, my lord, 75,000. relevant para.
Yes.
The relevant para is your lordships have relied all those Raunak International which are and at there are 13 Lord. Somewhere about 11 lines from the bottom.
Therefore,
besides this, the dispute is between the rival tenderers.
Therefore,
And it was a rival tenderers dispute, in which no element of public interest is. For yet another reason, no interference called for. As concession agreement has already been executed on 22/3/2000, the respondent has formed in all six separate special purpose vehicles for each of 6 BDA complexes as per provisions of the tender document. The consortium has already commenced project activities such as drawings and designs, evacuation of shops in the BDA complexes, mobilization of funds. Therefore, any interference at this stage would result in delay in implementation of the project. Well, in my case, project is completed.
No, that's why you.
Over.
What is the answer? That I waited for completion. I did not delay the project. I waited for completion. Then, when I learned that they are making payment to you, then I filed bill. So this judgment does not apply. That's the argument of petitioner.
There's a data conflict.
Yes. Anything else?
Your lordships have referred one judgment in Norman and another judgment while sitting in Jammu and Kashmir. Your lordships have referred.
Oh, where is that?
I did not finally.
But
that multiply the cases.
Oh, yeah, one is enough. It has a no. This even this division bench judgment also. No. Division bench judgment also. This single bench decision of Karnataka High Court has a persuasive value because the division bench of this thing Telangana High Court is considering this issue, right? Okay. Yes. Anything else? Yes. Please.
Entire law is only on the so long as there is no arbitrariness. If there is arbitrariness, that can be interfered. But so far as EO10 has referred, that there in fact earlier contract was only for 5 lakhs. That has been enhanced because
by the time when they entered into picture, the red GO was there. Subsequent GO was issued.
Yes.
Cement rate has increased, no, from 1 year to year. Sharply.
No, but suppose maybe a tender was to be issued again, perhaps could have, and moreover, you're laughing at 2 different contracts. One has given lesser, 1.75. Other player has given 3%. But they have carried on same thing. They were giving both the contracts to the same person again.
Yes, Mark. What you are supporting? What you are supporting the petitioner? Fine. You are supporting him. Fine. So mark everybody's presence. Argument cert. Case is reserved for delivery of judgment. Madam.
All right.
The previous one is to me. And advocate from Delhi. This matter we have to
We are very grateful to you, Lord.
Yes.
Taking so much of pain and pain.
No, it's on this.
Any other question?
Which number is petition? Which petition? Which number is this petition? Next. So we'll continue tomorrow, Mr. Right, tomorrow. Be brief in your submissions. That's what I can. We have heard you already for 1 hour and 20 minutes. No, every day. No, madam, every day is tomorrow, probably maybe the day when this matter can be concluded, right? Because every day we don't know. You people are ready with the matter. On today, there were so many matters and we heard 2 cases finally, therefore it couldn't be taken up. Tomorrow, the position may be different. There was a pressing need in this public interest litigation because the interim order operating against him. That's why, and petitioner said that instead of vacating you here, so that's why you see within 10 minutes, I mean 20 minutes, both of them have concluded. We have given you 1 hour and 20 minutes, still shown no signs of conclusion. What to do? Ask senior counsel, these are different times. Good old times are over. I have myself seen second appeal being argued for 2.5 days, deciding the question whether it's a lease or license. That we can't afford now, taking into account the pressure of work. You will appreciate. Please tell senior counsel to be brief. He has already argued. We have heard him. List will continue. Yes.
My lord, 158,
It will continue, Mr. Tomorrow.